All right, apologize for the delay, but let's go ahead with your questioning.
So, all right, Mr. Claiborne, you had a chance to look at your list.
Yes, sir.
Is everything on your list a fair and accurate depiction of items that were A, in your house when you got dispossessed of it, and B, items that were not in your house when you got them back?
Yes, sir.
And as the values, is there a fair and accurate value of all the items that you've listed in your
Yes,
list?
the best that I was able to find old receipts or get old receipts or, or look the stuff back up online, from where we had bought it in the past or something like that. It was the closest I could get to the value of it.
So, Judge, here's the formal list, and it was attached to the motion. Ms. Childers should have it. I'm going to ask that be moved into evidence.
Will this be Exhibit 1?
Yes, sir. And we're going to go through these photographs fairly quickly. We've talked about Mr. Claiborne. And again, as a blanket question to all of these photographs, would you say all the photographs that we're going to show here, and you're familiar with the photographs, correct?
Yes, sir.
I have these on OneNote, and you signed on to that.
Yes, sir. I looked at them again the other night. Yes, sir.
And you've looked at every one of these photographs, and you know the order that they're going in.
Yes, sir.
You've looked at everything that I've seen,
Yes,
everything
sir.
that I've done, correct?
Yes, sir.
And are these a fair and accurate depiction of these items, the ones that you do have photographs of?
Yes, sir. It is.
And again, all of these items that we've got photographs of, they were in the house. You took these pictures while they were in the house prior to your dispossession.
Yes, and you can tell that they was older pictures that was took, originally in the house before, over the years.
So let's look at this number 15 Dyson air purifier.
Yes, sir.
You have that.
Yes, sir. I have
Pointed
two.
to.
I have two of those in the home, and I paid $500 a piece for those at Best Buy.
Okay. And how many of these are you missing?
Two of them.
Okay. What do they do?
They heat and cool the room. It purifies the air. You can use them like they turn heat on or
It's a trick
whatever.
question. What does an air purifier do?
Well, they do different things. He's saying this heats and cools, and the one that I have is like $50. I mean, this is that's what I'm
Yeah,
asking.
those actually rotate, go up and down, and they move around, and then you can heat a room up with those things and everything. Yeah, those are nice.
Yeah, those are the more expensive ones,
Yes, sir.
right?
Yeah, I paid about $500. I think it's $500 a piece for them.
So, go to number 18, the Oakleys with the red lids.
That's a picture of my late wife with those glasses on when we was in Florida. I believe there's another pair. We was down our place. We had a place at the river when she was alive, and that was me on one, probably this Sea-Doos or something with those glasses on.
This is your number 18 and 19.
Uh-huh.
And what are these?
That was two of the. I had to see the names on the bottles, but I don't know if that's my two Xanax bottles that was left at the house that we found in the trash. That would be the two Xanax bottles that the doctor had put me on for sleep. That was missing. One of them was full, and one of them was about half empty. And when we started going through all the trash that was left at the house, those were the bottles that was found empty.
That's your name on that prescription, correct?
It is, sir.
Blow it up. Same thing here, correct?
Yes, sir. That's the other bottle because one was full and one was empty. I mean, when I left the house, one was half empty and one was brand new full.
Was it concerning to you that you lost this type of scheduled?
Yeah, that's a controlled
Scheduled
stuff. I
drugs?
mean, you had to show my ID and everything to get those. I mean, to me, luckily we found the bottles.
All right, and 26, that's a fair and accurate depiction of the riding chaps.
It is. That's a pair of my older chaps that I had when I rode my bike in the wintertime.
Towels and wash rags.
Yes, sir. That's
Item 36, now this is the,
we call it Roomba that runs around the house all the time. It's missing. It was just an odd picture. I think it was found on one of my old phones that I took over. My late wife had sent to me or something, another one of the text messages or something.
and you got this valued at $900, correct?
Yeah, when
That's
we
pretty
originally
expensive.
bought them was when they first come out. And it was expensive. Yeah, we bought, I think, originally at Lowe's when it first come out, I believe. And that's the pictures of my Ray-Bans that are missing that was left at the house.
What's that a picture of?
That's a picture of my daughter at a wedding wearing one of the rings of her mother's that's missing out of the jewelry box, the blue topaz, her looking down at the ring. That was a gift. The picture was a gift to me from her friend's wedding. The picture is even gone from the house too. That's showing the mattress pad off of the bedroom downstairs. It's missing. We paid several $100s for that downstairs.
Now, item 46, you got that valued at $300.
Yes, it was a nice mattress pad to go over that bed.
Supporting document that shows what you paid for it, correct?
Whatever that was, yes, sir.
That's a receipt for what you paid for it, correct?
That's for the bed, I believe. That's for the bed, the mattress, I believe.
Okay.
Yeah, we paid $3,000 for the mattress. And that's how it was when we come into the house that day. The topper and all the comforters and everything was gone off of it, and everything was gone out of the room.
And the $3,000 mattress still there?
The mattress still there, but the topper and the comforters, everything else is gone, the pillows, everything.
What is this? Item 52.
That is an older picture of downstairs before we put shelves in down there that started some of the liquor collection. That's some of the older liquor that was downstairs. But when I re-entered the house, that shelf had been moved up to the office and had been staged with other stuff in the office of the house. And then all the liquor that was downstairs on the other shelf was missing.
You got that valued at $400, correct?
What now? No, the liquor.
No, I'm sorry.
No, the liquor missing from the house is about $5,000 or $6,000.
The item 52, yes, $3,000.
Yeah, the liquor part that was downstairs was probably $3,000. Then there's different rooms that's got different amount of liquors we kept in different rooms.
$400, I looked at it wrong. That's his KitchenAid mixer, correct?
Yes, sir. That's the one that I had purchased for a Christmas present.
Okay.
For birthday, I think.
And these are the receipts for that purchase, correct?
Yes, sir. That's the one for the coffee pot there, about $200 and something, I think, for the coffee pot or something like that.
Coffee maker.
Yes, sir.
Item 57.
Yeah, that's one of the two. I had two of those Yeti killers are matching. One of them's missing. They left a strap to it downstairs in the basement, and then all the other Yeti cups are gone from up there inside. They had like a big gallon. That out of all the dishes, two skillets were left, and those red ones, whoever the red ones are, they was never at the house when I originally left there. They don't even belong to me. It's some kind of cheap ones you use for like camping or something. Those are some
64, these air tags.
Yes, they was on the kitchen table the night that I left. I had just purchased those.
That's a receipt where you purchased this, what you
Yes.
looked up for the value.
That's a receipt from Amazon, I believe, or that's where I just purchased from Amazon.
It was an air tag.
What is an air tag?
You put like to keep location of your like keys or whatever you put it on or whatever. It's just a thing Apple makes. Is all
Okay.
it, yeah.
And it helps you find things?
Yeah, it helps you find things, whatever it is you're looking for. Or if you keep it on something, you can track it or whatever with.
Is it concerning that they were missing?
Yeah, because they're brand new, never been opened up or assigned to a phone or anything. Yes, they're still on the package.
What is this?
If you look in there's like a wine bottle sitting upside down. That's an older picture from when my late wife had took her grandkids there. There's a bread basket that come from Africa that one of our friends had purchased in Africa as a gift while they was over there. And that's what I was able to find it online. The exact one online looks like it. But that one there had originally come from Africa.
Hummingbird feeder?
That was my late wife's hummingbird feeder that was underneath. I had it stored, put up underneath the kitchen cabinet in the living room. The kitchen.
Dog food container?
Yes, sir. Those were the two drink holders. It was in a brand new refrigerator that I had just purchased. That was in the refrigerator.
And they were gone?
They were gone.
72 is what?
There's a stool. There's a white stool right there that's missing.
And then
That's where all the liquor that was in the kitchen, that whole thing was stocked full of liquor in the kitchen from corner. Now, some of that liquor that was in there was Miss Childress's, I will say that, but the majority of it was mine. I think more of the mixers were hers.
and you valued what you're missing then at $600.
Yeah, 'cause that whole thing above, that whole kitchen cabinet above the microwave was full of liquor.
And
That's where I had went back to Boswell Harley Davidson and had to buy another key and remote for the motorcycle that was missing.
You got this listed as totes of bedding they're missing?
Yes, sir. We had took those pictures after my daughter had moved out. We stored some stuff. I had to remove. We stored some stuff upstairs and took pictures of it, and that stuff there is all missing from the attic.
Again, that's a blue and white blanket that's
Yes, sir.
missing?
That's one of the blankets that's missing. That we had took a picture up there, and that big white tote that was in the attic it was in the bedroom now when I returned. And then here's the picture of the bed when I come in that day, and we pulled the comforter back on the bed, and it showed we didn't have no sheet on it that day, and had mismatched pillows still across the top of it. And then when you, sorry. And then go ahead.
Go ahead and finish your statement.
And then when you pull the comforter all the way back on one of the other pictures, you see where the whole mattress had been peed all the way over. Somebody had peed on the mattress.
We got that coming up. What is this?
And that's showing the closet to where all the vacuum cleaners were at. There was a dehumidifier. A dehumidifier where you a dehydrator for food that was in there. Everything like that was in that closet. The mop buckets was gone. Everything's gone out of that closet.
And you got a vacuum cleaner here missing at $400?
Yeah, I just purchased it at Best Buy also.
And then this is the mop and cleaning supplies at $400?
So that was all that was left. The whole thing was stocked with wood cleaning supplies, paper towels, everything. There's the actual picture of the dehydrator right there that I had just purchased off Amazon the prior year.
And that's the dehydrator?
That's actually an actual picture right there where I was making jerky one night in the house with it right there. Then there was a picture there. That's how the hallway closet was. There was actually somebody had took some of the stuff out of that other closet and put in that closet, and there was actually also a pack of baby diapers in there with wipes, and I've never had no baby diapers or wipes in my house in years. So somebody had a baby, I guess, in the house there also.
Describe this photograph. Let's stop for a minute and describe this.
So if you see where the arrow's pointing, there's a half of a whiskey barrel there that's set in the living room of my home. That whiskey barrel had probably, I don't know, $500 or $600 worth of liquor in it right there. That's a picture of it right there sitting in the home prior. As I just random pictures. It's sitting behind another gentleman's car. There's my daughter with Miss Childress there loading a bunch of my stuff into the back of her Jeep that's coming out of the house. That's not supposed to be removed from the home.
And this photograph depicts that whiskey barrel is probably getting loaded up as well?
Yes, sir, because she bought me that whiskey barrel prior to us getting married before a Christmas present when we first started dating. So it was mine before we got married.
What is this? Oh, blood pressure testing?
Yeah, that was just showing the one that's missing from the house. It's just that little air cleaning kit that I kept in the living room is gone. That's one of the vases with the candles in it that my late wife had purchased and had an older picture I found that was missing. That shows the two candle. If you look in the picture, the candle holders right there, that was some of those candle holders. I had bought them after my late wife passed away at Bed Bath & Beyond. I think Bed Bath & Beyond or somewhere up there. When I returned to the home, somebody had turned the gas on and left the gas fireplace running, and they took the shut-off valve to it. I had to turn and order another one off Amazon to be able to cut the gas off coming into the house. They'd left the fireplace running. That's showing a picture of the bed that's missing from the home. It's actually in Mrs. Childress' storage unit that I had stored it in, along with the dresser, the matching dresser that goes along with that bed. It's an antique bed that my late wife had prior to us even getting married. That's how the bed is.
And it's our position that was not in the house when
Yeah.
I want to make sure about this.
Yeah.
That was not in the house when you got dispossessed of the home.
Yeah,
It was in that storage unit.
It was in her storage unit. And that's actually the picture of the dresser that was in her storage unit too that belonged to my late wife.
But according to the order, she should have left that at the house. That was your separate property.
Yes, sir. That's all my property. Yes, it belonged to my late wife.
All right. And then we got towels.
Yeah, I buy those 1,000 at a time for the business, and that was I had just purchased those on Amazon. I order them off Amazon for work.
That's a receipt for your leaf blower that you've listed
Yes, sir. I
here.
bought it at Dixon County Farm Equipment here in town. That shows the model and serial number of it. That's
Wreaths that are missing.
Yeah, it's just some of the odd and end decorations that are missing, wreaths and other things from the house that are missing.
You've got those valued.
Yes, sir.
Receipt for a battery charger, is that correct?
Yes, sir. I had bought a battery charger. I keep odd and end batteries charged around the house, and then have I keep a lot of stuff on battery tenders, like the motorcycle or side by side or my boat or something like that. I have all kinds of battery tender chargers on everything at the house. that for the oil?
107, 6 gallons of antifreeze.
Yes, sir. That was the oil. I'm the antifreeze I purchased for. I keep a lot of stuff stocked, a lot of chemicals and lubricants stocked at the house for work, in case one of the other guys that works for me needs it. They can come by the house and get it, or they have the code to get into the garage to get something out if they need it.
Again, receipts for your antifreeze and things of that nature?
Yes, sir. I buy them at a couple of different places. If I can find it on sale at another place, I'll purchase it there.
This is number 109, which is
It's a snap-on battery charger for my smaller batteries I use on my smaller electric impacts and stuff at work. If I use one of the electric ones, that's two of the 3 of the missing batteries that are missing also. That's my wash wand for my side by side and some of the fluid that's missing also. I never even took it out of the box and even used it because I hadn't had it that long.
110 and 111 right there on your list.
Uh-huh.
Number 113 is a water separator for a forklift.
Yes, sir. I buy those in bulk usually because I have my bigger account where we service them constantly every month, so I have to keep that stuff in stock, and that's some of the ones that are missing.
Would this have been?
And it should have been sitting on the right-hand side of the shelf when you first walk in the garage, is where it should have been.
Got it. And this is where you've looked it up and got a value for it, and that's what you're showing the court, correct?
Yes, sir.
And then 115 is listed as just a power cord.
Yeah, all my power cords are and adapters and all that stuff. All that I got all those in different totes and stuff, and all the totes with all the power adapters. Everything's missing from the home.
This is where you've looked up the value of a.
Yes, sir. I just bought
Drill.
that. I just bought that drill
Drill
bit set right there. Yes, sir.
Item number 118. I'm going to go through these pretty quick. This is just tools
Yes, sir.
that you've got for your business that are missing.
Yes,
All of this look familiar to you?
It does. I don't know what that receipt is. It's for something. I'd have to.
And then this is 122.
Some more of the decorations that was stored in the garage. And that's those were the flower pots that my late wife had that her grandkids had colored and put their handprints on. My late wife's grandkids, that's their actual handprints that was painted into the pot. They stuck their hand down in paint and put their hand on the pots.
Did Miss Childress know this?
Yes, sir, she did.
She knew this?
Yeah, because her and my daughter had talked about those before and stuff like that.
Is there any good reason that would have been gone?
I have no idea why they would be gone, because they just knew there's something that has no sentimental with her.
He's mentioned his late wife so many times, I kind of feel like I should show this. Her name was Kimberly Lee, and she passed away August 2021 from COVID. It's super sad. She was only 47. And it's obvious that he is still not over her passing, and he moved on way too quick. And that's probably what got him into this mess.
And then there's, in that corner of that picture, I went back through some old pictures, because right after my late wife had passed away, I took a picture of her car. When I put it in the garage, I had it detailed and waxed and parked it in the garage, and you can see the rhino liner right there in the corner of that picture. That's one of the rhino liners that's missing, the whole gallon of it that's missing. It should have been sitting there. And then there's a snap-on stool right there. That's an older picture of another refrigerator we used to have in the garage.
And again, this is a 127 receipt for air filters.
Yes, sir. Those air filters, I keep 3 or 4 different kinds in stock at all the time at the house, and usually anywhere from 12 to 24 of them. And the ones that are missing, there are multiple fits. They can fit multiple different things, even down like the side-by-sides and stuff like that. But they're mainly for forklifts, but the ones that are missing can be multi-used on different things if you have a side-by-side or something like that.
Right. These are various receipts just to show what they cost, correct?
Yes, sir. It's just receipts. I was able to go back to the place where I bought stuff where I had on my email. Then that's another picture, an older picture from the house. It was took actually showing where the motorcycle was when I left the house, but you can also see in the corner over there the hydraulic fluid that should have been at the house that's missing from the house. But then when we come back to the house, the motorcycle had been moved over to the other end of the garage.
Same thing. You're showing this as a receipt where you replace the items that were missing,
Yes.
and this is the bread cleaner that was missing.
Yes, sir.
Replaced
There were
it for
several
that.
cases of it missing. Yes, sir. I keep all that stuff overstocked at the house.
Okay. Black RTV number 135. What is that?
It's like silicone. Like we put like a part on the engine. We got to have some silicone gaskets or whatever.
All right.
That's the older pair of Oakleys that I kept in the saddlebag of my Harley when I rode my bike. They were missing.
Yeah, this is number 138, which would have been receipt for tools. that
Yeah,
you
I think I
replaced.
just purchased those off eBay. Maybe that may be an eBay receipt or an Amazon receipt, one of the two. I bought some tools off eBay a lot for work.
And then the same thing here.
Yes, sir.
As I'm looking at this, this is all stuff that was in
It
the
was left at the
garage.
house because by the time I bought some of that stuff was right around whenever I was removed from the house.
Again, this shows what the price of all that is when you went to go.
Yes, sir. That was back on my
replace it.
bank transactions from my business account.
Okay. What is this?
That is a picture that she had put online of her tiller for sale. That's actually one of my late wife's tables that she used to, when she did some painting that she painted off of. That's one of the tables that's actually missing from the house. Because there was two of them at the house and only one of them was there. I think one of them's there right now, but one of the ones is missing from the house.
This is a towable tube that goes with a boat.
Yes, sir. That was brand new, still in the box. Had never been took out of the box. I'd bought it at Bass Pro Shop. It was, I think I paid about $300 for it. $307. It was still in the box. And that's the picture, probably of the other Yeti cooler that's missing from the house because there was two matching coolers.
6 surveillance cameras.
Yes, sir. There's that's two of the cameras. There was one, and there's actually a picture of Logan Brown actually taking the camera off of the back of the deck, and that's actually the camera that caught the altercation that morning on tape at the house that's missing from the house.
Okay.
That was a picture of Logan taking it down.
Is there any reason he would have taken that down?
I don't know. I mean, I bought the camera. I don't know why they want to steal the camera and take the camera from my house. I don't know why she would have Logan up there taking a camera off the back of my deck.
And this picture was compliments of your neighbor, correct?
That's compliments of my neighbor right there. Yes, sir. And that was the camera.
Previously testified.
Yes, sir. Yes, sir.
And that's just another picture.
Yeah, that's
of him
another
taking
picture of him
down.
taking the camera down from the house. And that was, I think, a couple days right before she actually moved out of the home, I believe.
You've listed on your list here, and these are, well, so you've got a receipt here for a lot of the alcohol that's missing. that
Yes,
you
sir.
knew
Probably
was
several
there.
$1,000s, but probably in total. I mean, some of the alcohol I'd bought over the years when my late wife was still alive, I collected. Like I said, there was only one signed bottle. A lot of it was mainly more high-end bourbon bottles of liquor. There was probably, $5,000 or $6,000 or more worth of liquor in the home.
This is showing what it costs. These are the
Yes, sir. Yes, sir. That was some of the receipts I was able to go back and find. But there's a picture down there that shows. That's a picture that was put online for Annabelle Brown, one of the girls that was actually in the hot tub picture of the house that was staying in my home with Miss Childress, that she'd put my Ray-Bans online for sale, because you can tell the picture was took at my house because you can see the white curtains in it that Miss Childress hung up in the home after I had moved out of the home. Or not moved out, was took out of the home.
Did you know Annabelle Brown?
I did. I mean, her mother used to date back off and on years ago.
Okay. And she was at your house?
Yes, she was one of the ones that we testified before in the other court with the girls that was in the hot tub party in the hot tub in my house.
And you do believe this is her selling your merchandise?
It is, yeah, because you can tell the pictures took inside my home off the glare of the sunglasses.
Oh, okay, I see what you're saying.
Yeah, you see the glare, and you can see the white curtains that was hung up in my home.
Off the glare in the sunglasses? Okay.
Yes, sir, yeah. So that shows that picture was not took inside my home. That's the two rings that are missing from the home. Well, I take that back. That's the only two pieces of jewelry that was left at the home whenever I got back to the home. Miss Childress put that picture online of my wedding band and my late wife's wedding band, with a picture of my late wife that's actually missing from the home also. And you can tell that picture was not took inside my home. That table's not in my home. That's the house, like it's got paneling in it wherever the picture was took. It was took right back down offline as soon as it was put on. But that shows that she took the jewelry out of the home right there. That's a picture of my jewelry outside that home.
Took the jewelry out of the home, then it was back. This jewelry was back.
Yeah, that's the only two pieces of jewelry that was left at the home, and they were sitting on top of that jewelry box inside the bathroom whenever we entered the home. That was the only two that was left there.
Is there any reasoning for her to post that picture and put this message
It was
on
a
here?
shot. It was a shot online at
Irrelevant.
me, is all it was, and my late wife,
Honor,
because she knows how
irrelevant.
disrespectful that is.
We have an objection. What?
Your Honor, I feel like this is irrelevant
What's the
to
motive
the
as to
post.
why she?
It clearly the items weren't stolen. They're in a picture and you just stated they were back at the home.
Objections is to relevance, but I believe he was, if you're objecting to the photograph itself, overruled. If you're objecting to him, asking him why this would have been posted, I think that obviously would require speculation. I'll sustain the objection as to the question regarding why this was posted online. Go ahead.
But the bottom line of this, your testimony,
Yes, sir.
this is in your house.
That picture's not taken in my house, and that's one of the pictures of my late wife from high school that's also still missing from the home there. And like I said, that table was not in my home, and that house, that's not the color of my home. My house are repost gray in the walls of my house. And I have no paneling in my house.
Judge, if I may, I've got the thumb drive that's got all these pictures on it, Exhibit 2 collected.
Does that conclude our photographs?
Yes, sir. You've also put on your list, there are items, things missing that has no dollar value on it, correct?
Yes, sir.
And there's just no way you're gonna get the sentimental value out of these
No,
items.
there's before my late grandmother passed away, she had made all of the kids quilts, either a starburst quilt or a wedding ring quilt, and she had made me a homemade wedding ring quilt that she sewed by herself. That quilt is probably, if you valued it, I mean, it'd probably be $500 to $1,000 quilt. It's an older quilt, but I mean, there's really no value. It's a sentimental thing. All of my late wife's stuff is missing. I mean, from her phone, a lot of her clothes, all of her jewelry is missing from the home.
Hold on, you got tax records that are missing
Yeah,
in this list?
all of my tax records are missing. We found a couple, even all the way down, the tax records that belonged to her and her first husband of over 20-something years ago are gone from the house. Yeah, there's tax records that go back that far that
Your
are
business
missing.
records?
All
Your
my
records?
business records, my business license. I mean, there was nothing left at the home that pertained to my business at all.
Apparently there was a private leather, item 155, a private leather briefcase.
Yes, sir. That had a lot of our personal stuff in it. She would do work for the company, or even her place she worked if she went into the office. She kept a lot of her personal documents in there that pertained to the company she worked for before she passed away. And then a lot of stuff that pertained to my company as far as, customers' information. There's all kinds of customers' banking information missing.
Titles to vehicles?
All of my titles of the vehicles are missing. I've had to go get titles replaced over at the tag place here in town.
Christmas ornaments that are
Christmas
special
ornaments.
to you?
Yeah, the older stuff is missing that belonged to my late wife. A lot of the newer stuff is still there, but majority of the stuff that belonged to my late wife is what was missing. There was still some of the stuff that was still there, but it's just like somebody had picked through some of the stuff.
I'm sorry, Judge, if I could, I want to ask you about the hot tub. The vandalism pictures were kind of separate.
That's the piece that the chemical cartridges set down in. When I pulled it out, there wasn't any cartridges in it, and that right there had been broke. That shows the filter and all the puke that we cleaned out of the hot tub, where the filters were clogged up with, I guess it was puke, and that's where I started cleaning the hot tub out there. You can see there's two of the beer caps there that was found down in the bottom of the hot tub, and there's another picture that shows where they was rusted over, sitting in the bottom of the hot tub. Right there, you can tell where they'd been down in the hot tub, and I don't drink beer or nothing like that, so it wouldn't have been mine.
And this is a estimate of what it was to.
That's just from me going back and buying the filters and the chemicals. That doesn't include the time of me spending cleaning it and everything else. There's the actual picture of the mattress there where somebody had pissed all over or urinated all over it.
And you got receipts there where all that was
I
cleaned?
did. I spent about $800 or $900 having a company come out and clean the mattress.
Picture of the urinated mattress, please. Go back to the picture. I didn't get a chance to see it.
You can see the whole mattress, how it's been turned yellow right there. I guess the hardest part of that to me is my late wife stayed in that bedroom the last week of her life, and that's the best she slept in the last week of her life. That's why I take that picture right there more personal than anything. Because I left that room. That room still sits today just like she left it.
Yeah, I think we talked about this picture already, but that's the Fecal matter in your clothing, correct?
Yes. I don't, that was that was a mat or a rug that we have on the back deck where a fireplace was, and I don't smoke, and then somebody was burn holes all in it. And then that's where we started going through some of the trash and found bags and bags of cigarette butts. There's the white powder, the first picture of the white powder that was found down inside the motorcycle. And actually, I think that's maybe Officer Lashley or Hunter standing over there, whichever one was standing over that day right across from it. You can kind of see some of it there. It's even around on the sides of the tank and stuff right there also. You can see the white powder going down through there right there on it also. That was.
What is this, a picture of?
I think that was the water.
water.
Yeah, that was the water that come out of the tank of the side by side. When we drained the tank, we put all the water. Actually, we drained it over to a 5-gallon bucket originally to begin with, and we siphoned some of it over into that. And that's what it looked like after we siphoned it over.
And as a mechanic, you understand how to do all of this?
Yes, sir. Yes, I'm a certified mechanic.
And this actual contents of this bottle is what was in the side-by-side?
Yes, sir. That one, yeah, that one's pretty much, it was, like I said, 90% water was in the gas tank of the side by side. That right there is a picture of where she had hung all kinds of things over all the doors and windows in the house after I left the house, and took it down when she left the house, because that stuff was never there. We never put it over the kitchen window or the back door windows.
Just kind of on the side of the neighbors where she testified she was trying to put up stuff?
Yes, sir, it is. That's the one, on the back, where the neighbors, that faces the neighbor's kitchen, is from our kitchen to their kitchen there. And then where she,
all of these holes and all this
yes, sir,
damage?
yeah. And that right there is a picture where she put chain locks over all the doors inside the house, in the bedroom, all the doors, even the front door, the back doors, even that's in the master. That's where she'd put something over the sliding back door that goes outside. There's some scratch marks from where they'd move stuff. There's the doors down, the main front door downstairs, where they'd put stuff over the front doors downstairs, black the windows out. That was some marks from on the wall. That's just more marks on the wall. That's on top of the dresser in our bedroom. That bedroom suite's about 3 years old. Me and my late wife had purchased that brand new bedroom suite right before she passed away. And somebody took something there and put like a sander or something other down inside the sink and put all kind of swirl marks down inside the sink, and you can see there.
That wasn't like that when you
No,
left
sir. This is
home?
brand new. This is a brand new home. And then that was where somebody had stuck something down inside the commode, left all kinds of black marks inside the commode. That's in the master bathroom right there. That was where one of the animals, I'm assuming, she left outside all the time before she left the home. That was the screen over the back sliding door that was tore plumb up whenever I got back to the home.
Judge, if I may, as Exhibit 3, you prepared a list of all of the vandalism that's going on in the home.
I did, sir. Yes, sir, I did. From what I've been able to tell.
And is that your list?
What is Exhibit 2?
It is.
And I would ask this to be Exhibit 3, is a list of the vandalism that's at the home. Have you put a value as to the vandalism?
I mean, well, you figure the time that I've had to spend on it, I've had to basically shut my business down and either pay the guy that works for me to come over there and work. So you figure our going labor rate right now is $140 an hour on a new customer if they call. And so you figure that's per person. So you figure $280 an hour that I'm losing a day, just sitting there having to pay him to come over there and work at the house, that I've had to shut the business down probably for a week total off and on, that between having to work on the motorcycle, the side by side, and everything else, that I've had to shut the business down to be able to get my home back in order to even live in it properly and feel safe.
Do you have an amount that you were looking, I know you put as item 17, there was $775 for carpet cleaning and cleaning the mattress?
That's what I
and the
paid.
urine?
That's what I paid a company from Spring Hill to come out and do.
Any other values that you can put on any of this damage? I mean, give me a number.
Well, should have been another receipt for we had a painting company. I had a painting company come out. I think it was $900 or $1,000 what they was going to charge to fix all the holes in the walls and repaint the trim and everything that had been messed up. It was a receipt for them, or an estimate from them on that.
$900?
I think it was 900 or 1,000 or something like that. It was about $1,000, I believe.
As far as the other stuff, is there a value? You talked about just overall time and things of
Time,
that
whatever
nature.
you figure an 8-hour day would be at $280. You figure a week of that, because that's what, like I said, that's both of us average a day is 280 an hour. So you got to figure that.
And Judge, the photographs that I've shown, I'm gonna ask those be put into evidence as well, so next collected, but they're on that thumb drive as well. All of those photographs, I forgot about that, all the vandalism photographs are on that one thumb drive that I handed in.
Right. We'll show that vandalism, all of that thumb drive contains all photographs.
You had 3 guns.
Yes, sir, I did. When I returned to the home, like I said, both officers searched the home for the guns. None of the guns, none of the ammo or the holsters was there. That kind of become top priority to try to find 3 missing handguns. It was
One of the detectives contacted her and you got 2 of the guns back,
yeah, I believe
correct?
Detective Lovell went to her residence wherever she was living at. I don't know where she was living at, and she told him, from what I heard originally, that she only had 2 of the guns. I believe.
One of
he
the
said.
guns is at
One of the guns right
Sheriff's
now.
Department right now,
is
correct?
one of the guns. After the fact, we had to file a police report on a missing gun, and then I believe Detective Martin reached out to her, and she told Detective Martin that I'd physically give her the gun, which is not true, because that was one of the guns that my late wife had purchased for me before she had passed away, saying I would never get rid of something my late wife passed.
One of your relatives has 2 of those guns back.
Not my relative. A friend of mine has them. She has them locked up in their safe at their house.
There's one outstanding that Detective Martin still
Yes,
has,
it's
correct?
supposed to be at the Dixon County Sheriff's Department right
And
now.
he's saying that he wants some sort of indication from a court as to whether or not he can give that gun to you, correct?
Yeah, because he wants to know who to legally give the gun to. I mean, it's registered in my name, so I never gave the gun away.
Point of information.
Let me ask this question. What type of gun is Detective Martin holding?
It's a little black 380. It's got a laser sight on it. It's like a little palm handgun.
Brand, what make?
He's got the original receipt on it over there. I can't remember
That's all right.
I can't remember the exact name of it, sir. But it's when we have one of the receipts for it where I purchased it at that Golden Eagle Pawn in Dixon, brand new. Or my late wife gave me the money for it.
Smith & Wesson, 2 Smith & Wessons and a Ruger. Which
Yeah,
one is it?
one of them's a 45, one of
Which
them's a
one does
9.
Detective Martin have?
The 380, I believe. Is that what it is?
The Smith & Wesson 380?
Yes, it's one he has.
And that's the,
Golden Eagle Pawn. Yeah, that's the one he has right there.
that's the receipt that you bought it in May of 2020.
Yes, sir. That's the gun that's still missing there.
Well, it's not missing. We
Well,
don't
we know.
have
Physically, it's not missing, but to me, it's missing.
All right. Point of information, Judge. So we're just taking up this one motion, which I'm fine with, and then we're going to kind of reset the rest.
It's 10 after 4, you're not going to finish even with this motion, much less get to very much more, so you're going to be looking at whatever's left being rolled over to another day. So we'll stop with this motion and then allow Ms. Childress to cross-examine your client whenever you're concluded on the motion, this motion at least, and the rest of the motions will all have to be heard on another day.
Yes, sir. That's all I have for this one. Thank you.
Childress, you may cross-examine, and I would remind you that we're only dealing with this one motion about all of these issues that Mr. Hawley's gone into, and you need to ask questions rather than make statements, okay?
Yes, Your Honor.
And let me just say that Monday we have a criminal, well, tomorrow I have Fox Hardwood versus Jackson, which is supposed to be an all-day contract dispute, non-jury bench trial. Then I have Monday a criminal docket call, and jury trials are set all of next week. So we'll have to talk about when these other motions might get heard, but it's going to be a while. All right, go ahead. I'm sorry.
Mr. Claiborne, you stated many items in here that you said you purchased, correct?
A lot of there's a lot of the stuff I've had, majority I had before we got married.
So, ma'am,
You may. You'll hand that to the
Yeah, I see it before.
if you could read the date.
The date, December the 31st. It was bought under my business account on my business through the business.
But that was bought while we were married, correct?
The business purchased. Our marriage did not purchase that. I bought it
Again,
in
that
business.
was purchased while we were married, correct?
And then again, it was purchased through the business because one was bought for the
You need
office.
to answer her question first.
It was bought while we was married, but it was bought through the business. I did not purchase it myself with my own money. No, the business purchased it.
Why did you purchase it?
Purchased one for the office and one for the bedroom.
I believe you purchased one of those.
No, I did not. I did
You
not.
can testify, you can ask
Okay.
questions.
So you purchased both of
I
them?
purchased both of those.
Okay, fair enough. But you would say that those were purchased during the marriage, so they're not stolen. They're not
They
your
was
personal
purchased-
property,
They was
correct?
purchased through the business, yes.
Mr. Claiborne, do you recognize a hummingbird feeder?
Not off the top of my head, unless it was the one that was purchased and took down to the graveyard, but that's not the one that's missing from the home. There was one that was bought and took down to the graveyard. The one that's missing from the home was underneath the kitchen cabinet that belonged to my late wife that she put outside every year that I took down and put it up so nothing would happen to it. And that's not even the picture of the one that was showed here in court.
And that's a receipt from
I have no
your daughter,
idea.
Sydney Claiborne.
Okay, then that's the one she purchased and took down there to the house, because when that picture was took there, that's not the one that was took down to the graveyard.
So, but that was the one that was at the graveyard, correct?
I'm assuming, I don't know, but that's not the one that was at the house. So that was not at the house. The one from the house was put underneath the cabinet.
And your daughter purchased that.
I have no idea who purchased it. I don't know.
Okay, we'll move to the next one. And line item number 55.
Okay, those are yours. There has nothing. That's not what's missing from my house. It's not on my list.
You called out crock pots.
A crock pot, yeah, a red crock pot that belonged to me and my late wife. A red one, not two. These are that you bought for a Christmas party. That's not what I have on the list missing. I have a crock pot. That was the three that you bought for a party at the house.
Okay, so yes, I did purchase 3.
Yes.
But you're saying that there was one missing?
There's a red one missing from the house that me and my late wife had purchased together before she passed away that we've had for years.
Do you recognize the items in those pictures?
I do.
Do you recognize where those pictures are taken at?
Those were taken at your dad's house in Nashville.
Okay, so could you mention the reference number that's on those items?
123.
So on 123, you stated in your motion 2 large black totes with yellow lids.
Yeah,
Can you describe those?
Those
for
are
me, please?
barblet toast, but you had some and I had some, and most of yours were all to the storage unit over in Dixon. If you had one whole, you had 2 units over there, and one of the units was stacked all the way to the top with black totes.
Do you have receipts for those?
I'd probably go back through somewhere through Lowe's. They've been bought over the years.
Are those part of the unopened air tags that you stated were purchased?
No, that's not. That's the air tag right there with the one that Sydney left at the house that she kept paying, that actually me and you took down to the White Bluff Police Department and actually turned into the police department to offer to that one that arrested me 3 times.
So
Yeah, no, that wasn't even at my house when I left. That's actually at White Bluff Police Department right there.
So when were the air tags purchased?
Right before I got removed from the house off Amazon, off of the business account. It may have been off the business account.
And during that time, were we married?
We were married, but it was purchased through the business. The business is separate from the marriage.
Did you not assign those air tags?
No, I did not. They had not even been opened up. There was a brand new packet that hadn't even been opened up. There was more than one pack. Some of those had been opened up, yes, but there was still more that had never been opened up.
How many packs of air tags were purchased during the marriage?
I cannot remember. I have to go back, pull my Amazon up and look. Because you carried one on your keychain. There was one in the other work van, and then I think that was the only 2 that we had purchased, maybe 2 more off of Amazon. Those were the ones that was left at the house that had not been opened up.
And the ones that were purchased, you purchased, correct?
I believe it's off Amazon.
And
yes.
you assigned those to my vehicles in your work van, correct?
No, I did not assign to your vehicles. You had one on your phone that you assigned from your phone to your keychain, and the other one that was in my other work van was assigned to my phone and my location.
So you're saying we purchased 8 air tags?
No, you took one of them. I never assigned it to you. There was 4, I believe 4 of them originally purchased at 2 different times.
Again, the air tags were purchased while we were married, correct?
It was purchased through the business.
Was everything purchased while we were married through your business account?
I purchase about 90% of my stuff through the business, so that way it kind of protects me from the business separately. And everything, that's why I always use the business account. I use my personal account hardly for nothing.
I mean, it's 90% of what you purchased for your business. 90% of that applies to the items that we needed to purchase while we were married.
We didn't buy much while we was married. We bought a few things together, a computer desk and some other stuff. And you purchased some odd and knickknacks to the house that you took when you moved out.
Again, many of these items on this list were items that were purchased while we were married, correct?
No, it was not. Not when you go back to when you've got stuff from 20 years ago that me and my late wife purchased together. All of her jewelry gone, everything else. I mean, me and you purchased none of that.
This goes along with that one.
Okay, so mixer that's missing from the home.
You stated that it was missing from the home. However, one of those text messages is for you to return my mixer from one of your daughters, and the other mixer.
And you got that mixer back.
The other mixer. Can you describe what that picture is?
That's the picture of where I had purchased it for my daughter for her birthday. That was at the home on my counter when I left, because when I had her removed from the home, I kept the mixer there, along with the missing coffee pot that I had purchased too that was missing from the home.
But you would agree that you purchased those as a gift for your daughter, correct?
Before I had her removed from the home, yes, but they were missing from the home and they was not to be removed.
Please
from
answer
the
the question.
I answered the home.
Did you purchase those as a gift for
I
your
purchased
daughter?
her as a gift for my daughter, but they was at the home when I left.
So those items do not belong to you, correct?
Yeah, because when she left the home, when I had her removed from the home, the items were left at the home in my possession. And we actually have a letter from Sydney Franklin, her requesting the items.
Describe who that text message is from.
It's from Sydney.
Can you tell me what it says? And what's in
It
the
says, I
picture?
found another
To
matching.
hearsay.
Sustained, statement made outside of the courtroom that you're introducing is in fact hearsay, so sustained, it will not be admitted.
Yes, Your Honor. Actually, Your Honor, if it's a text message to me, can the piece that I can testify to be admitted into the courtroom?
Statement made by any person outside of the courtroom that's being introduced to prove what's said in that statement to be true is hearsay, which means that even if it's a message to you, you cannot testify about it because of the simple fact that unless there's some other basis for it to be introduced, but because it's still, you're repeating what someone outside has said outside of the courtroom.
Yes, Your Honor. Can you describe the picture that's in the image that's captured within that text that I sent?
It's some missing stuff from the home. There's pictures of the blankets and stuff that's missing from
Can
the
you
home.
describe those blankets?
I mean, they're green and white. There's a white comforter up there in one of them.
And those are mentioned as stolen as well, correct?
They're missing. They're not stolen technically. I can't say stolen.
So that text message is, let me rephrase that. Those are items that were located up in the attic at the home, correct?
They wasn't there when I returned to the home, no.
In that picture,
I don't remember exactly when the picture was taken.
there may be a date on there.
January the
Judge, I'm going to
14th.
object to the hearsay. If there's a date on this thing, it is hearsay. He didn't take the picture, so we can't authenticate the date. If there's a date on there, that would be hearsay.
Saying he can't just read a date on a photograph if he didn't take the photograph.
Yes, Your Honor.
If you took the photograph, you will be able to testify about the date.
And these are, okay. Can you describe those pictures for me? More specifically, is that the hall closet in the upstairs of the home?
That wasn't like that when I left the home, no. That stuff was not in that hallway closet when I left the home that I can recall, no.
So
I don't remember that like that, no. Because it's showing all these food containers and stuff right here. These food containers and stuff should have been in the kitchen.
okay, fair enough.
If I remember correctly because that one of those wooden baskets right there is one of the wooden baskets that was brought out the night by you when the police would let me go back in the home and get my stuff. So no, there was more than those in the house. And that meant my medicine was kept actually in that hallway. I believe that hallway closet that night. So yeah, that picture was took after I was removed from the home.
That picture was not.
That was not how the hallway was that night I left, because you was crying and screaming that there was no dog food at the house, and that was testified to in White Bluff Court that you couldn't feed the animals, but there's a whole cases and cases of dog food right here.
Again, that picture was taken while you resided in the home.
I don't recall that
I'm going
picture
to
being
object to
there.
the testimony.
I'm just going off what you testified to in White Bluff, that you couldn't feed the animals.
There's an
but-
objection on the floor, you need to stop
sorry.
talking. The objection is to, or making a statement. Mr. Polly?
Well, it's relevance and it's hearsay on a picture that he can't authenticate at this point. He's testified to some of the generalities of it, but she's getting more into the exactness of it.
Sustained.
You stated that I stole your, is it Ativan, lorazepam,
What is it?
that was removed from the home?
The what?
Lorazepam that you had to take. You showed pictures of it.
That wasn't the lorazepam.
That's incorrect. There were
Xanax.
pictures of it. Yes, that's the generic name for
Okay,
Xanax.
well, whatever's on the bottle, yes. But I mean, yeah, there was 2 bottles that was left at the house. I mean, I didn't.
While we were married, did I take that same prescription?
But not under my name, when those names are on my bottle. Those are my
But
bottles.
I took that same prescription,
I
correct?
don't know. I remember you took them, but I don't know what milligram you took, to tell you the truth. You took so much stuff, it's kind of hard to tell.
That's hearsay.
Judge, I'm object to the argumentative.
Well, just answer the question, don't volunteer additional information, and you don't respond if he does.
Yes,
You
sir.
can object to what he says as being non-responsive.
Yes, Your Honor. 1 milligram every 8 hours is needed. Can you state for the courts what your milligrams were?
Without seeing that picture up there again, what the milligrams were, no, I cannot
enough.
recall.
Okay, fair enough. Do you recognize that document?
I do.
Can you read off can you tell me who the complainant is?
It would be me.
So can you read off the items that were allegedly stolen from that home?
We're missing from the home is it was one of the rings, a golden weaving basket ring, that we had a picture with her on,
Can you state the value of that ring that you listed?
probably $1,000 maybe,
Can you read what you stated in the police report?
that the ring was missing from the house.
Let me specify, can you state the dollar value
I said
that is on that police report?
probably $1,000. It was something my late wife would have bought.
I don't need probably, I'm asking you
It
to
said
read.
$1,000 is what it was on here is what she probably would have paid for it, is what I'm assuming.
What is the dollar value that you listed on the police
I
report
said
for the value of the
$1,000
ring?
is about probably what she would have paid for it, is what was listed on the report.
Can you flip to the front page and specifically read off the items that are listed with their dollar value?
Judge, I'm gonna object. What's on the front page, and this is a police report, he wrote some things on the back page, which is fair game, and I've let her question. But this front page, this police report's not been authenticated properly, and first time I've seen it, I didn't know what was going on with it.
Police reports are not typically admissible as evidence because of the fact that they constitute a report by an individual who is not a witness, even if the officer is testifying, the report itself would be hearsay.
Yes, Your Honor, I can redact it and reword it.
All right.
Some of the stuff on here is not even mine anyway.
Okay, I can redact it and ask the question another way. So you stated that the ring was $1,000 and that it was
That was my estimated guess of it.
and it was your late mother's, right?
No,
Or your
my
late wife's?
wife's would have been something she had purchased probably.
Can you identify the person in this picture?
Can I see that, please?
That'd be Sydney.
Can you tell me what she's wearing?
That ring is missing.
The $1,000 ring
I'm assuming that's it. It looks like it. I
that
don't
belonged to
know.
your late wife?
That's one of the rings that's missing of my late wife's.
Can you flip the page, please?
Okay.
Where there's just the ring listed. What is the dollar value of that ring?
Judge, I'll object to
$60.
Your Honor, it's
the
relevant.
authentication for the document at that point.
Because I don't know that that's the
first
same.
page was okay, but I don't know anything about this other.
Your Honor,
When I told you a minute ago that you don't talk when there's an objection on the floor, I actually meant it. So
Sorry.
be quiet until I hear what they're arguing about. What is it, Mr. Holly?
He's testifying from a document that's not been authenticated. I'm testifying to hearsay and the proper authentication. When we flip the page and actually look at something that somebody else has printed, I understand that the one page I saw was he identified that as his daughter, so I'll let him testify to it.
Your Honor, the pictures that I presented, I actually printed myself, and the relevance is because there are multiple items on this on this motion that has been filed that have already been previously reported to other law enforcement agencies in an attempt to bring false theft charges against your own daughter.
Well, you'll be asking him a question if you're arguing to me. Number one, at 4:30 in the afternoon, we're going to adjourn this hearing. And all I can tell you is I don't have another date unless it's a regular chancery date, and we put it at the tail of the docket. So the next chancery date that we have is September the 6th, and I'm assuming that's going to be a full day. September the 7th. September the 25th.
and there's Jennifer Roberts, Kay Taylor Brown on there. That's a final hearing. She said it was going to take quite a bit, but we can put it on that day.
Your Honor, for planning purposes, I do have an 80-page document. It's a spreadsheet with every line item that's been mentioned in this motion. I do have the evidence, I do have pictures, I do have videos, and I do have receipts to support it to review.
Good to hear, because I've already ordered you to provide discovery to Mr. Holly, and that is the type of document he's entitled to hear or to review before we come back to this court. This case will be reset for for September the 25th. We'll take up the matters that are already set, and we'll resume this case after the regular docket on that day.
Thank you, Your Honor.
You have already been ordered to provide answers to the discovery that was requested, and that would include this 80-page document you're referring to. So,
Yes, Your Honor.
Mr. Claiborne, you may step down, have a seat by your lawyer. Court stands adjourned.
Thank you, Judge.
All rise. Court is now adjourned.
Ms. Childress Claiborne, we are not able to take up your entire case today because of the lateness of the day. Mr. Holly has a number of motions that have been filed, and one of his motions is a motion for default. Is that correct?
Yes, sir.
This is a motion for default judgment. Right. You may argue your motion.
Judge, I'm looking at the order from the August 24th day that we were in court. This court signed that. I think I got it yesterday or maybe the day before. And
I don't have it in the file, I don't think. It may be in the file. Yes, I do, I'm sorry.
and it was not pro tunc. We were here that day, and it was announced on the 24th day of August. You made a specific announcement to Ms. Claiborne about the discovery and what needed to be done. And I put that in the order. Everybody knew about it from August 24th. But that part of the order, that the wife shall provide full and complete answers to all discovery questions previously filed by the husband within 30 days of today's hearing date, or sanctions may be imposed. She came by the office on Friday and dropped, and I was out of the office on Friday, but she dropped off answers to discovery. I'm going to give the court, if I may, for my motion, tender copy of what she gave. They, first off, are not notarized as they are required under the rules of procedure. Glaringly, when I looked at these kind of over the weekend, I noticed the answer to like the very first question that is there concerning her income, and that would be
Which question are you referring to? Because the question number one on the copy you've given me is, have you ever been arrested?
right. Looking at the first question about her income, to provide me her current employment. Let me get my bearings here. Number 3, if you're employed, please state the name and address of your current employer, brief description of your job, immediate supervisor, base rate of pay, attach your last 3 pay stubs.
Involving alimony, or is it?
This is a temporary motion, is what we're in the midst of right now with all those filings, but no, this was a 5-month
I
marriage.
was going to say they've been married for 5 months.
We have not asked for spousal support.
All right, so why do you need to know what her income is?
Well, I take that back. She was asking for spousal support, and she's got a motion. The court said you wouldn't hear that motion at that time because she hadn't provided an answer to discovery.
Right.
When we were here that time, I objected because I didn't know in the discovery questions, and I had filed them. This has been going on since, and I go back and look, I believe since February of this year, asking for discovery when Mr. Baker did represent her, and I know he got those. But when I look at this, she didn't provide anything regarding her employment. She is employed by Metrocan. My staff actually verified that on Friday. What you got is a copy at the front of this of a discrepancy letter that we did on Friday. And and I'll give that to her at some point. It might have been mailed already, but again, she dropped it off on Friday. We just did that actually on Friday afternoon, my staff did. But they realized there wasn't any of her current employer. They called, they verified. She's working at Metrocan. I went back and looked at my security footage, and I can pull this up for the court. She shows up in a blue shirt that appears to be a Metrocan, shirt, and I've got no pay stubs. I've got no mention of it. She hasn't told me about that. And again, for someone that's, asking for spousal support and things of that nature, that's an important question. The bank records show several transfers from different banking accounts, I believe, that she's done, and I've got basically a couple of accounts. And I don't have anything that refers to the account number that those EBs are coming from. And I noticed there were two separate bank accounts that she's transferring money from, looks like herself, and that has not happened. I do not have anything in the record of her answers, to put that together. She talks about, produce fully, one of the questions, request, produce fully and all copies of email, text messages, letters, things of that nature. She apparently in the discovery has said that she doesn't own a cell phone anymore. She's thrown them all away. When I asked for social media posts, her answer to that is she's disconnected from all social media, and she's not able to go back and retrieve any of that information, which the court can take judicial notice. You can still go back and retrieve that information that's logged in on your account. So the full and complete answers as to what I've stated are not there. And it's been quite the while, been months, she's had available to do this. She brings it into my office on Friday afternoon. There is a listing there of, we went over, if the court will recall, several photographs of what the house looked like with the TV in place, and then the TV's gone and that kind of stuff to show the missing items. The powder around the Harley gas tank. There's a lot of vandalism to the house as well. She didn't really address a lot of those things. The people that came to the house, again, that question is not fully answered, in my opinion. But moreover, the most glaring question to me, among all the others, is just she refuses to tell me her current employment. She's done that now for quite some time. I don't know why, when you are working and apparently working possibly that day, and you walk over to my office in a shirt, what appears to be your employer's shirt, and then you don't answer discovery that way. And it's just basically, in my opinion, she's just not going to answer this discovery properly. It specifically says it's supposed to be notarized and sworn to, and she has failed to do that in the many months that she's had it. So I am asking for a default judgment. Mr. Claiborne's here. He does have two witnesses that can testify about the marriage. We are still asking for approximately, I think it's around $43,000 in, missing and damaged items that court's already heard testimony on. And she's cross-examined Mr. Claiborne on that. So that would be the biggest, and I said this in my opening statements with that motion, this is a divorce. It's a 5-month marriage. But that's not really the time frame that we're looking at in this. It's the time that he was arrested for the domestic, which we highly contest. It's set for a trial, I think, in March of this year. Now it got continued. To the time that he got the house back was just a couple of months, actually. And that was when all of this damage did occur. But I've got witnesses that can testify and put on some proof as to their knowledge of all of that as well.
Well, looking at it, I want to make sure I'm understanding what it is that you're saying she's not fully answered. Your interrogatories that you handed me are question number 1, Have you ever been arrested? It says see attachment. There is no attachment that addresses that issue. Is that correct? Number 2, please state your full name, including any alias. See attachment. There is nothing in the attachment that I see just looking at that addresses that answer. Is that correct?
Yes, sir. I don't see anything.
Question 3. If you're employed, please state the name, address of your current employer, a brief description of your job, the name of your immediate supervisor, pay, et cetera, et cetera. It says see attachment. And again, unless I'm missing something, I don't see any information that is supplied in the attachment that answers that question. Number 4, for all checking, savings, and retirement, account 401 stocks and bonds. Now, there are some bank account records that are attached that says see attachment. Number 5, during the course of your marriage, please state each and every time that you have been to a place called the Red Room or any equivalent swingers club by way date, name and address, names of unknown of individuals with whom you had a romantic and or sexual contact while at said facility. It says, again, see attachment. There's nothing that I see in the attachment that addresses the answer to that question. Then we go forward to number 6. And it talks about the names of every person that was on that property of the marital residence. Have a seat until I call you. Every person that was at the marital property or marital residence by name, date, time, and so forth says see attachment. Again, I see nothing in these answers that are attached, rather, that would answer that question. Please state specifically with each and every account to your knowledge that deals with the estate of your father by way of the name of the financial institution, et cetera. And again, I don't know if these bank accounts are the ones that would answer that question or not, but it says see attached. During number 8, during the time you occupied a marital residence while he was not allowed on the property, it talks about her driving the Nissan Armada, plate every trip she took in the Armada, the date, purpose of the trip, et cetera, says see attached. I see nothing that would indicate that. Number 9, number 10, number 11, number 12, number 13. 13 might be potentially answered by the attachment of her descriptions of the property and so forth.
It is.
And number 14 would not have been answered. Number 15 would not have been answered by that.
No.
Number 16 would not have been answered. 17, assets which you consider to be marital property. I would take that her listing of those property items that were there and so forth that she's gone through, that might be potentially answered. Number 18, identifying the name of every male or female with whom you've had sexual intercourse, oral sex, et cetera, says see attachment. There's nothing to indicate that. 19, whether the plaintiff has been a good spouse, says see attached. There's nothing in that indicates that. Goes on about witnesses and every other. So the great majority of all your questions were just simply appears to be just I don't know if that's a stamp or what, if it says see attachment, but on every one of those it's see attachment, and none of those things seem to address the answers to your questions.
Because I would say even some of those that you brought up, they didn't even put down in the deficiency letter, but I would rely specifically on my deficiency letter as well. You go through that, that's all the concerns that I've got. And as you can tell, that deficiency letter, it's a smooth 2 pages, almost 2.5 pages here of things that she has left out as well after we went through it. And I've kind of confirmed that a little bit with that letter.
When you ask for sanctions, you're asking for me to grant you a default judgment, strike her pleadings, and just allow your client to proceed with the divorce.
Yes, sir.
The other option is that I grant your request for sanctions and bar her from presenting any proof on any of these issues. That's another option that I have.
Yes, sir.
All right, let me hear from Ms. Schroeder's Claiborne.
Thank you, Judge.
Your Honor, first of all, this is the first time I'm hearing about this default judgment. So So I didn't bring anything to prove otherwise. However, when that documentation was dropped off at Mr. Hawley's office, there was indeed a separate attachment that detailed, and I believe it was 6 pages long. And I have a copy of that in my desk drawer at work because I made myself a copy and I left him one. And I can prove to you that that was turned in because Mr. Hawley himself even made mention about my cellular devices and my Facebook not being able to provide those. And that was also in that separate attachment. And I did in fact answer every single question on there to the best of my ability. When he's talking about my employer, most of those questions were answered in April. I just did not complete those because a lot of it had to do with the criminal investigation. So the only answers that I had to go back and put in was in fact the ones that were pertaining that I had not answered before. Mr. Hawley is fully aware that I'm working. He's mentioned it in here several times. However, due to the amount of stalking and harassment that I've gone through, I mean, his client has been indicted several times now on stalking and violation of order protection and bond conditions. I don't feel safe providing my work location and address, as well as my home information, as well as my social security number, my driver's license number. I mean, but I did answer with the exception of I did not update my employer. At the time that he served me with those discovery requests, those were in April, not February. We had not even filed for a divorce at that time. We were still living together. They were sent to me the middle of April, and I did answer those. And I actually have the email at my work where I did send the answers that I had to Olin Baker. I did answer to the best of my ability. And in those motions that you have currently, I did answer those to my best of my ability. Why Mr. Hawley has left my attachment out, I don't understand, considering he has provided the responses verbally in this courtroom. Aside from that, the last hearing that he mentioned involving the $43,000 of items, not counting what the cost of the house being vandalized is, I only got 15 minutes to 20 minutes during court last time, and to cross-examine Chris, I specifically said, I have hundreds of receipts in Facebook posts and communication where the majority of that stuff I did purchase. I have that information. I did provide him the spreadsheet. And I also have witnesses as well as video and pictures to submit to the court. The video was taken at 5:08. There's pictures of all of us pulling out onto Highway 70 at 5:13, 5 minutes later. No one was in the house supposedly for 3 days. So, I mean, I need the opportunity to present those.
Well, you've been given the opportunity on cross-examination, but we did not finish the trial. So the hearing, and when we came back to court the next time, which was theoretically going to be today, you were going to be given an opportunity to resume your cross-examination.
Yes, Your Honor.
I wasn't cutting you off, but it is that. We are not obviously going to be able to take it up today and get anywhere with it, so we're going to have to find you another date. In the meantime, I am going to simply pass your motion for sanctions, Mr. Hawley, until she is allowed to produce what she says is her answers, that she says she provided an attachment, which I'm not seeing in what I've been given. And if she produces that, then we'll consider whether or not your sanctions are appropriate or not. At this point, Mr. Hawley, I'm going to file what you have provided to me with the clerk, and just advise you that you need to get with the clerk here about resetting this motion, and then we'll go from there.
And Your Honor, I advise Mr. Hawley that if it's reset for October, I'll be out of the state the middle of October, from the 10th until the 18th. So I just request that the next hearing not be set during that time. It's arrangements that I cannot.
Out of town from when to when?
From the 10th until the 18th, and it's something that I've already paid for. It's a
Well, this would be an appropriate case to have heard on Halloween, October the 31st.
Yes, Your Honor, I'm
We've
too.
already set,
Some of them made a Thursday, Friday's not waiting for it, maybe to that day.
they have been moved to the 31st. Did I give you that date?
You just did one, no.
I know, but how did you move everything that quickly?
On my email, I sent emails and told them they had that was an option.
Judge, if I can, this has been reset twice. That whole back row has been here. I've got one lady that's not going to be here on the 31st, but I'd
We're
ask
going to hear
her.
this on the 31st. We'll just have
You
to,
did it first, I mean, that's you,
what did I set on the 31st already today?
from the night, you didn't, you said, you said.
Miss Robertson, oh, okay, that's the 10th. All right, we'll set this first on the 31st to finish this hearing.
Thank you, Judge.
Thank you, Your Honor.
All subpoenas can be continued to that day. So everybody's in the
Everyone
courtroom.
who's under a subpoena, I apologize. We have too many cases to get heard in one day, and as a result, this matter can't get heard. It was last on the docket. It'll be first on the docket on Halloween. We'll see you all then. Everybody continues under a subpoena for that.
Thank you, Judge.
Thank you, Your Honor.
Court stands adjourned. Time I've got, so. All right. See you. All right, we have two motions to quash in the Claiborne case that I've been handed. Claiborne versus Claiborne. Is Miss Claiborne, Childress Claiborne here? Go out in the hallway and call in Miss Childress, Amy Lee Childress Claiborne.
Because of the rule last time, you used to step out.
By the way, anybody that feels aggrieved by the fact that we don't have enough days to get your stuff heard, contact your local representatives of the state legislature, both the state house and the state senate. In fact, call every one of them, because for the fourth year in a row, we were up to get a fourth judge. And for the fourth year in a row, everyone around us, Montgomery County and Williamson County in particular, were awarded additional judges, and we were not. So there is no rhyme or reason for why that happens, except for the fact that we all kind of have an idea of why it happens. So, Ms. Childress Claiborne, we are ready to take this matter up. Is the rule requested?
It has been, Your Honor.
The rule has been requested, so if there are anyone who's going to be a witness in this case must go outside of the courtroom and remain outside of the courtroom until you are called to testify. You are not to discuss the testimony of any other witness with anyone prior to this, and that includes watching any live stream of this proceeding.
Your Honor, I plan to call Miss Stacy Davis as a witness as well.
Stacey Sanders, if she's going to be called as a potential witness, then she'll need to go outside.
And I'm sorry, also Pat Jones as well as the neighbors.
Have you subpoenaed them?
No, Your Honor.
Then if you haven't subpoenaed them, you have no right to necessarily force them to leave the room. Mr. Holly, do you wish to waive the rule regarding those witnesses to allow them to remain, or do you want them out?
Only without subpoenaed, they're not on her discovery for any witness. I don't have any witnesses listed. I mean, that's all news to me who she was going to call today. So
Your Honor.
I'm not willing to waive it.
Your Honor, ever since March, they've all been out in the hall as potential witnesses.
Out of an abundance of caution, Mr. Holly, let's have this lady that she's just designated go outside. I'll make a decision whether or not she's entitled to call.
Great.
Judge, may I interrupt briefly? May I step downstairs to circuit court until Piper is called later, if it's called?
You can go anywhere you want to between now and Piper.
Thanks, Judge.
Because I have no great confidence that we're going to get to the Piper case, because it is last on the docket. So.
Yes, Judge. Thank you.
All right, if those witnesses are outside of the courtroom, then I am in a position where I want to hear this motion. We have two motions to quash.
And I still renewed, and I refiled my motion for default judgment as well, Your Honor, for today. I put together the discovery, and
well, let's first take up the motion to quash. You are here, if I understand, on the motion to quash, Mr. Mills.
Yes, Your Honor. I'm representing the town of White Bluff. 2 officers were subpoenaed by Mr. Holly, and Mr. Potter's here on behalf of the county. A county detective was subpoenaed. Ready to take that up if Your Honor is ready.
Ready to go? I assume that's something we need to address on the front end, simply
Your
because of
Honor.
the fact that it will determine how many witnesses are available and what evidence is available.
Your Honor, the gravamen of the motion is that under Rule 45, non-party witnesses must be given 21 days to respond. These subpoenas were issued on October 20th, 11 days ago. So that's the main thrust of this motion. As to the subpoena ducis tecum, which compelled testimony and the production of a pretty wide range of documents, evidence, and tangible things, which we have not had a chance to review. I believe the White Bluff officers were served last Wednesday, issued 11 days ago. Also, there are criminal investigations that are pending that involve both parties. So if the court denies our motion to quash as to these subpoenas and requires their testimony, we would ask the court to limit their testimony to any facts unrelated to those criminal investigations. So that's the basis. I don't know if Mr. Potter has anything to add for the county for Detective Lovell.
It's the same argument, Your Honor. I think that the county detective was subpoenaed to appear today and give testimony. The same argument Mr. Mills has made, asking for a lot of documents, records, papers, electronically filed information, etc. Certainly it was issued less than 21 days ago and served even later than that. And so I think there's an absolute right to declare the subpoena ducis tecum void ab initio because of the time frame. But if Your Honor compels the testimony of this officer, as Mr. Mills pointed out, it's our understanding that there are pending criminal investigations, that there should be some limit on what the scope of the testimony.
Mr. Holly, did you issue a subpoena?
I did. A couple of them. 2 White Bluff City officers and then Detective Lovell, who is with the county on behalf of, that's what Mr. Potter is arguing. First off, Judge, I don't have any issue with the testimony going to whatever is civil in nature. I agree with that wholeheartedly. Part of the reason for the delay in these subpoenas is the lateness of the answers and the discovery that I got. If Your Honor is looking at my motion, when we get to my motion here in a few minutes, what you will know is that she answered the discovery late on a Friday, September 22nd. I had that Valdez case on Monday, a couple of other ones. I'm in the office on Sunday trying to figure out and make sense of the discovery. As I was looking at the discovery, I was taking her answers, looking at it, looking at the questions, flipping it over upside down and doing that thing. And I left her answers upside down on my desk when I ran out of there late Sunday night to get everything prepared. When we came to court last time on the default judgment, the answers that were filed with the court didn't include her written answers. I've corrected that today in my filing. I put everything together, explained that in my motion, and it's all there. It's still grossly deficient. I still want to take up my default judgment momentarily. Part of it, if you will look, and I can pass it back, but part of the problem that I had was when she answered the discovery, when I wanted to know where all of these items were. In this case, this motion for contempt is about her cleaning out his house. You heard the testimony of the officers already. But I get this with typeset that is, I don't know, 1/8 of an inch maybe. I had to get my magnifying glass out to look at it. It's riddled with some of these things now she's claiming she gave to the officers. And there's some different kind of stuff she gave. I don't know why you would need, there's like a sugar tester for your blood. There's some things in there. I have no idea why they would need that in an investigation. But she claims she gave it all to Officer Suddeth, Chief of Police in White Bluff, Chris Fulcher, and Steve Lovell, detective. My question for them is, do you have it or do you not have it? Is she telling the truth? Is she not telling the truth? My understanding, I expect the evidence will show, Officer Sutter said whatever he got, he gave to Detective Lovell. Chris Fulcher's out there with one air tag he said he had, and that was all that he has. And that's what the evidence is going to show. Detective Lovell says he has a couple of boxes of things out in the car that if, told to come in or wants to, inquire about that, he does have those things. But that was the reason for the lateness. By the time I had a chance to look at her discovery and determine that from the 22nd of September late in the day, which I think if I calculated right, it's about 10, 12, 13 business days. By the time I had a chance to read her discovery where she's now saying that some of these items went with the officers, that's when I said, well, we may need the officers here to figure out what exactly she gave. I've spoken with, and Detective Martin, Troy Martin is in this, I've spoken with him. She claims there was a lot of stuff given to Sheriff Eads. The evidence will show with Detective Martin, he investigated that. Sheriff Eads didn't have anything. There's a couple of things that Detective Martin's had. He's been here the entire time. I haven't seen him this morning. I hope he comes. I may have to call him. But the basic gravamen of what I'm after is not necessarily for anything criminal. It's just for these guys to testify as to what she actually gave them, see if it goes to the truth of what she's saying in her discovery. The discovery answers were not signed. Again, that's part of my motion here in a few minutes. They're not under oath now. They're nothing but just pieces of paper that were given to me. But that is what she has told me, and she gave it to me months late. I filed this discovery. I think the discovery is 6, 7 months late. I haven't looked at it in a little bit, but it was very late from the time she gave it to me. But I was scrambling to get them issued when I did, based on what she told me. I'm going to ask that they stay and at least provide that testimony to the court. They are here.
All right, Ms. Claiborne, you want to come to the podium? And this is, all I'm hearing right now is the motion to quash that's been filed by the town of White Bluff and Dixon County on behalf of these witnesses that have been subpoenaed.
Yes, Your Honor. The reason that I wanted to take this stand is I want to discredit several things that Mr. Hawley is saying. I believe
We're not arguing the motion. We're not arguing a motion for default. Focus on just the motion to quash the subpoenas that we issued. Did you issue a subpoena for these two officers?
No, Your Honor.
You did not issue a subpoena?
No, Your Honor.
Then have a seat. Since the subpoenas were issued by Mr. Hawley rather than Ms. Childress Claiborne, it is this court's opinion that rule pretty clear, as was set forth in the motion, that Rule 45.07 of the Tennessee Rules of Civil Procedure is styled, and this is important, protection of persons subject to subpoena. The purpose of the rule is to protect people who are being subpoenaed that are non-parties. Subsection 1 of that rule states as follows: a party or attorney responsible for issuing and serving a subpoena must take reasonable steps to avoid imposing undue burden or expense on a non-party witness subject to the subpoena, and shall provide the non-party witness at least 21 days after service of the subpoena to respond, absent agreement of the non-party witness or court order. Now, in my opinion, I am of the opinion that it is that rule would prevent the witnesses who have been subpoenaed to produce any documentary evidence, period, unless they've been given 21 days. But I don't see anything that would prevent them from being subject to subpoena to testify in person, and therefore I will grant in part your motions to quash as to the production of any records, any kind of documentary proof, but the witnesses who have been subpoenaed can testify as to non-criminal matters. Mr. Hawley has made that clear. That's what he intends to do. So their testimony will be limited to non-criminal matters. And if either of you wish to remain during their testimony to advise them, because since you are the attorney representing those witnesses, you have the right to remain during their testimony to ensure that they are not exceeding the civil portion into the criminal investigation. I don't want to turn this into a preliminary hearing for the criminal cases, and I'm not going to allow that to occur. So, go ahead.
Thank you. We'll advise the witnesses.
All right. Now, Mr. Hawley, have you argued sufficiently your motion for default?
Judge, I got a few more things to add. The court should have filed October the 5th from me a motion for default judgment. And this is, I think, more or less the second, maybe third time we've taken this this default judgment up. Every time that we've taken it, she's done a little something to carry it a little more further and get it continued. The bottom line with this is she's not answered her discovery yet. And attached to that motion, you should have everything that I got from her at this point. I looked at it closely. And again, the last time I was in court late on Sunday trying to prepare for everything, and she dropped this off at the last minute for our hearing purportedly on that following Monday. That Friday afternoon she came in, I was looking at the questions like we do, looking at the answers. I was flipping them over upside down and doing that on my desk. Looked at them really quickly. Didn't have time really to read the small print of the other answer, but I didn't flip that one back over and put it back in and have it in that stack to hand to you that following Monday morning. But I do now, and the answers are all there. I had prepared a deficiency letter at that time for Ms. Childress, and I stand behind my deficiency letter. It was still accurate because when my staff had looked at this for the deficiencies, that they had looked at her answers. The first thing I'm going to point out is in the 6-7 months or so since these things have been filed and outstanding, she still has not provided a signed copy under oath as required under the rules. That was made plain in the deficiency letter. The deficiency letter was sent back out to her again. So she heard about it all that day that we were in here. She got the deficiency letter. These answers have not been signed. And if you look at what she's missing, she didn't put down any aliases, obviously I know her name, but alias, social security number, and driver's license number. And those are pretty stock questions, and I didn't get anything as far as an answer on that goes. See attachment, there's nothing in there. Please state your current employer as well as your last 3 months pay stubs. I got nothing. There's no answer to that question. And I would submit to the court, mainly we're arguing today about money in this motion for contempt. It's about the cleaning out of the house and all the things that when this court ordered that she would leave the home and have nothing damaged or destroyed, the court's heard enough to understand that's where we are with this motion. And she has a source of income here with her employer that ties into this at the very end if the court grants it as her ability to pay. And I don't have anything. I have confirmed with the office she does have and has had a job for quite some time at Metrocan. I can show Your Honor the staff footage of my cameras at my office. I believe she had a Metrocan shirt on when she dropped this stuff off on Friday. But she hasn't, and she refuses to answer that question. There goes on with bank accounts. There's issues with her father's estate, which again is money to her, which would affect her ability to pay. She's refused to answer those questions. Interrogatory number 22, I think, is important. Please state your witnesses, address, telephone numbers. There's nothing. And she comes in today and said, I'm going to call these witnesses. It'll be the news to me. First I've heard of it. And she refuses to answer that question about the witnesses and refused to answer about them in the overall case in the divorce. It affects today as well. Of course, there's other questions here. I'm trying to hit the highlights. The request for production of documents, obviously the pay stubs are not there, tax returns are not there, business statements, anything having to do with Facebook, and she has put quite a few things on Facebook regarding all of this, and there's nothing there. What she considers to be her separate property list, separate property owned prior to the marriage, recordings, anything of Mr. Claiborne, I have absolutely nothing of. And these are minus the recordings, I think. I don't know if there's any of that or not that she might have. But the rest of this stuff is all boilerplate discovery things that go to our issues here today. And it's the reason why things take forever is because you've kind of got to go off on a fishing expedition when you get into these motions or a final hearing when people don't adequately answer the discovery. I'm kind of in a hamstrung situation here. I do think based on the conduct of Ms. Childress and her flat-out refusal to answer these, I'm entitled to a default judgment in some manner. I would ask that the parties be divorced today, that put on some testimony about the proof if you need it again from him, but the motion pretty well sums everything up and adds it up. Or the only other issue with the divorce is I think it's 42,000 some odd dollars worth of property that she's absconded with or vandalized at his house. And Your Honor heard hours of testimony on that, saw the pictures, saw the receipts, saw everything that we put up on the stand. But it's just not fair for her to, be able to avoid the rules. I know she's representing herself, but this court, and she has been representing herself for some time, this court made it pretty plain, and it's in the order, that she was to provide a full, complete answer to the discovery the last time we were here, not to mention this time. And I've just failed to get anything that I can use. And again, the other thing that I'm getting, the court looks at the back of this where it says, she's listing and addressing that list that Mr. Claiborne did. I had to get a magnifying glass to help me out with that. I'm not as young as I used to be. My bifocals weren't working, but I submit to the court, if you see that, that's just another situation that we have to deal with in this case from Ms. Claiborne. And it's another way to just get a dig in as far as the whole process goes, which he puts it in font that's that size. Thank you, Judge.
Justice Claiborne, you may address the motion for default.
Yes, Your Honor. I guess I don't really
Happy anniversary. You just had your first year anniversary October the 3rd. So
Yes, sir.
I'm sure it was a joyous occasion for you and Mr. Claiborne.
Well, it would have been, but unfortunately, a week after I was in your courtroom, I lost my job with Metrocan. They eliminated my position after.
Well, I say that sarcastically because this was a 4-month marriage, and we are now a year into your marriage. You were married in October and filed for divorce. Mr. Claiborne filed for divorce in March of 2023.
Yes, Your Honor.
Anyway, more like a 5-month marriage, but in any event, divorce has been pending longer than you and Mr. Claiborne lived together.
Yes, Your Honor.
I want you to understand that makes a difference as far as the law is concerned on the length of your marriage.
Yes, Your Honor.
So I need you to address why you have not answered more fully the discovery pursuant to the order that I entered in August of this year.
Yes, Your Honor. So when you entered that order in August, you gave me 30 days to respond to Mr. Hawley. I did that. I delivered the discovery request in a packet on September 22nd. Furthermore, Mr. Hawley stated when we were in here last that I didn't submit my discovery responses at all, even though he was quite vocal in quoting my responses that I did provide. Now, Your Honor, when we were in court last time, you advised me that I needed to bring in my evidence, that I did turn it into Mr. Hawley, and those answers needed to be here today. Your Honor, I would like to present, I have a video on this thumb drive. 12:06 p.m. is when I walked those answers into Mr. Hawley's office. This is a screenshot of my answers where, in fact, interrogatory number 2, my social security number, 41151.
Don't say it out loud, please. This is being live streamed across the world. You don't need to put your social security number out there. Mr. Hawley, do you have any question about the fact that she produced those at your office?
I do. You have everything that she produced. I haven't seen what she's looking at here, but if she's going to.
Mr. Hawley.
Okay. And I'm going to disagree with you, Mr. Hawley, of the video where I handed it to Bobby in your office. There's a screenshot and there's my answers. And if you look at response number 22 that you previously called out to Mr. Wolf, I did in fact answer that as well. Not one of my responses was left blank.
Well, again, Judge, I just need a little bit of time to compare this with what I've got. For that being the case. I did not get this. This is not something that I got. This court, and if you don't have it, I sent that to the court attached to my motion as to what I got. That says see attached.
Well, Your Honor, I have no problem if someone can instruct me on how to use the computer. It's on my thumb drive.
What is?
the video of me with those responses on the top page, walking those into Mr. Holly's office from my Jeep, walking in to the only lady that was in the office was Miss Bobby, and you can hear me telling her, this is my discovery from Mr. Holly. I did a screenshot of that video, and that screenshot aligns with my answers. My answers were on the top. I recorded that for a reason, Your Honor. I have been drugged through the unimaginable with this attorney and his client, and I have had to document and cover my every move in my entire life right now. I have the evidence to prove I turned in the responses.
Well, if you desire to try to demonstrate that video, you may do so if you have the type of equipment necessary. I cannot try your case for you, Ms. Childers-Claiborne. You have the obligation representing yourself since your prior attorney has withdrawn. It is your obligation to put on whatever proof you wish to do so. But I want to inform you of the following. On August the 24th, this court put an order down that stated as follows. It is therefore ordered, adjudged, and decreed that the wife shall provide full and complete answers to all discovery questions previously filed by the husband within 30 days of today's hearing date, August 24th, 2023, or sanctions may be imposed. Now listen to me as I explain to you, because if you had a lawyer, your lawyer would know this, but you're charged with the same knowledge of anyone else. Each interrogatory, I'm looking at Rule 33 of the .01 of the Tennessee Rules of Civil Procedure. Each interrogatory, which is what we're dealing with, shall be answered separately and fully in writing under oath. So none of these have been sworn to. Mr. Holly's allegation that you did not sign them before a notary or provide them under oath, and therefore, and that if they have not been fully answered, then under those circumstances, they don't comply with the court's order. The Rule 37.01 is what Mr. Holly is referring to as far as what he's asking for default judgment, failure to make or cooperate in discovery sanctions. And basically, it provides that if a person fails to provide the answers under interrogatories that were required under a court order, that an evasive or an incomplete answer, for purposes of this subdivision, an evasive or incomplete answer is to be treated as a failure to answer. It allows the court to make award of expenses for the motion. Failure to comply with a court order. If a party fails to comply with an order regarding discovery, provide or permit discovery, including an order made under the previous order that I've done, then these are what the court can do. An order that the matters regarding which the order was made or any other designated fact shall be taken as established for the purposes of an action in accordance with the claim of the party obtaining the order. In other words, basically it says it's not a default judgment, but it basically says whatever Mr. Holly and his clients say is the truth is to be taken as the truth. Paragraph B, an order refusing to allow the disobedient party to support or oppose a designated claim or defense, or prohibiting the party from introducing designated matters into evidence. In other words, I can simply say, because you've not fully completed your discovery, that you can't introduce any evidence on these issues that are before the court. Paragraph C, an order striking out pleadings or parts thereof, or staying further proceedings until the order is obeyed, or dismissing the action or proceeding as any part thereof, or rendering a judgment by default against the disobedient party, which is what he's asking me to do. In lieu of any of the foregoing orders, or in addition thereto, an order treating as contempt of court for failure to obey any order except an order to submit to physical or mental examination. And then where a party fails to comply with an order under 35.01 requiring a party to produce another for examination, that one doesn't apply. So you see what the rule provides is pretty clear. You can't just submit a bunch of stuff and say, I've answered the discovery. Your answers have to be complete, directly responsive to the questions that were asked, and under oath. And in this case, those things have not been done. So whether or not you delivered some documents to Mr. Holly and have a video of it is not really the relevant issue. The relevant issue is whether or not you fully answered those discovery questions and whether or not that constitutes a violation of the order of this court regarding discovery entered in August, and whether or not I'm going to then allow you to put on any proof regarding those issues.
Yes, Your Honor. And I'm sorry, my point that I'm making is I answered every question Mr. Holly asked me. There's a printout. Mr. Holly has my documents. What I'm stating is on this thumb drive, those answers were on the top page because I knew he would pull this. And I walked them into his office and physically handed them to Bobby. And she acknowledged and took them. I answered every question that came my way, and I answered it within the time frame that you advised me to issue it in. The reason they are not notified, I have been very vocal since March that my name is not Amy Lee Childress Claiborne. My legal name is Amy Lee Childress. I do not own one government state ID with the name Claiborne on it. You have to have an ID to get something notarized. Mr. Holly is fully aware of what my name is. When he's sending the letters to Metrocan, on the outside it says Amy Childress. On every motion inside.
And you think that prevents you from appearing in front of a notary public under the name Amy Childress and signing the documents under oath?
Your Honor, I signed the documents that I gave to him. I do not have an ID that has the name Claiborne on it.
I'm going to take a recess. Mr. Holly, you compare what she's producing. When I come back, if she's able to produce a video of it, I'll allow her to play it, and then I'll make a ruling regarding. I'm going to necessarily have to examine what it is that you've asked and what her responses have been to determine whether or not she's in compliance with that. So we may not get started before lunch if I have to review all of that.
Yes.
We'll take a recess and allow this to take place.
All right.
Well, let me
Put them on a subscription, do they show up every month whether you need them or not? That's what I generally do. Stack them.
All right. Mr. Holly, you've had an opportunity to compare what Ms.
I have.
Childress.
It looks like a different typeset, or maybe that's the way she copied it. And that's what I was saying. I hadn't seen this before because of the stretched out typeset. I don't know how she took a picture of this thing. I've included this in my motion. This is in there, but it still doesn't answer, in my opinion, any of the questions that I brought up. Now, if you look at this interrogatory number 2, she states 102B West Hills Terrace, Sidney Claiborne. There's 2 numbers after that. I don't know whether that's her social security number, Sidney Claiborne's social security. It's that for the answer to that question. But outside of that, I'm still prepared to go through these line item by line item with several things that she's not produced, including the witness list, including all the other things that I mentioned, and they never were signed. She hadn't produced that. They've not been signed. They've not been affirmed under oath by her as required by the rules. But this is a different picture of what she dropped off, but it's in my October 5th motion. That's exhibit, I believe it's exhibit B, what she actually returned. So I still stand behind, as far as a list of everything that's not appropriate. If she's going to testify or whatever, that's her social security number, I guess that would be one answer to, again, the 2-page deficiency letter that's still outstanding. And I don't know how the court wants to do that, but if we need to go line item by line item, I guess I can.
What the court wants to do is to finish this case because this case has been pending for far too long, considering the length of time these parties were married. So there's no question but that these answers do not comply with the rules of civil procedure, nor do they comply with the court's order regarding the requirement that she fully answer those questions. As a result of that, courts considered all of the different sanctions that can be imposed on this, and what I'm finding is that the most appropriate is to to refuse under subsection 37.02 subsection B. The court finds that the defendant should be prevented from and prohibited from introducing any evidence regarding the matters that are requested in the discovery that you have filed. And therefore, she will not be allowed to introduce evidence on the issues that were raised in your discovery request, and you may proceed with your case. But I'm not granting a default judgment. She'll be able to testify about grounds and so forth, but as far as introducing a lot of evidence that's set forth in your discovery request, I'm not going to allow her to do that because it's not being complied with the order. You may call your next witness, Mr. Hawley.
Can I have a moment with my client? Just a point of clarification, as far as the answer not being signed, all of those types of things, she's not going to be able to put on any evidence for either questions that I've asked.
Correct.
And that's for today as well as,
That is correct.
unless she remedies it at a final hearing. I would then call Colin Deaver. He can be my last witness to call then.
Ms. Childress, I understand that you may not agree with my ruling, but the fact of the matter is that the rules require that those answers be filed under oath and that those are sworn to. And the reason for that is that the opposing party may rely upon them as an accuracy. Where the rules require it, there's no provision for me to waive that, and as a result, your answers were not sworn to. I understand your reasons why you've given them, but rather than grant a default, simply a default, I'm simply saying that you cannot you cannot put any proof on regarding those issues that were asked about in the discovery request.
Yes, Your Honor. I think the problem that I have with it is I have the evidence to prove that Mr. Hawley has been lying in the last 2 court hearings, and it's on my thumb drive. And regardless of what Mr. Hawley wants to state, I do have that factual evidence that I did answer the questions. The way those were typed out, the reason it has an address, my social security number, and my driver's license number, if you read the interrogatory questions, they correspond with what was provided. I did not feel the need to retype those, but I'm fine with not using any of my information. I do have every bit of all of my documents to support that I did not cause the vandalism. My witnesses are here, and I will need the court to allow time because I do have videos as well as a lot of documentation.
You understand what I've just ruled, that you're not going to be allowed to put on evidence regarding the issues that Mr. Hawley asked about in his discovery request.
Your Honor, Mr. Hawley did not ask
Number
about.
one, when I am talking, you need
Sorry.
to be quiet. So we're going to consider whether or not those questions were asked, and I'll decide whether or not. Raise your right hand and let the clerk place you under oath.
You solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God.
All right, if you will, sir, state your name for the record.
Colin Patrick Dever,
Mr. Dever, what is your address?
6501 Harding Pike, apartment T14, Nashville, Tennessee.
What is your last name? I'm sorry.
Dever. Dever rhymes with never.
Okay.
Never Dever.
Pull that base of that microphone towards you a
Sure.
little bit so that it picks up, please.
Is that better?
That's better.
That's
Okay.
better. You want to spell your last name for the court?
DEV as in victory, ER.
All right, thank you, sir. You know Miss Childress, correct?
Yes.
And y'all at one point were pretty good friends.
Yes.
I mean, she came to you with all these issues that she's dealing with Mr. Claiborne, and you guys talked about all of those things, correct?
She didn't come to me to talk about Mr. Claiborne. I found out about it after she asked me to pick her up from the hospital. And on the drive home, that's when she told me.
And you had spent nights at Mr. Claiborne's home.
Yes.
You'd stayed there for how long?
Every week I would spend like a few nights so she wouldn't be alone because she was concerned.
Mhm.
And, but I had, have my own place and my cat. And so I needed to get home and do things. So,
At one point, you became estranged from Miss Claiborne, did you not?
we had a bit of a falling out and, but
Is it because she wanted you to lie to
I
the,
object, Your Honor. I don't even know how Mr. Hawley can say that there was a falling out.
Number one, you have to object on a legal basis for an objection. There is no legal basis to say that you don't like the question he's asked. So overrule your objection.
I'm sorry, could you?
at one point, she was requesting that you lie to the police and file a false report about something that Hunter Anglin and Chris Lashley, the two officers that had previously testified, something that they had done. Is that accurate?
Not that I recall.
You don't remember anything about that at all?
I do not.
So
Our falling out.
you're
was-
saying that she never wanted you to make a false statement to the Dixon County Police Department?
Not that I recall.
Not that you recall?
No,
You think you would recall something like that?
I would think so.
I want to plug in here and put something on the screen if the court will allow. And if I can plug in. I'm going to show you a text message. I want to ask you if you recognize this text message.
Yes,
You wrote this, did you not?
right.
Can you read that for the court, please, sir?
You wanted me to make a statement against the Dixon County Police Department. I would not do that as I thought they did nothing wrong.
Well,
But
I'll show you another Facebook post and ask you if the last paragraph is something that you wrote.
yes,
That's on your Facebook account, and you wrote this.
yeah.
Can you read that last paragraph for me, please, sir?
She wanted me to say the officers did something wrong. I said I would not agree with that.
No, the last statement, being a good Christian, that paragraph right there.
Being a good Christian, I find it hard to bring myself to use this kind of language, but she's fucking crazy bitch.
Go ahead.
She wanted me to say the officers did something wrong. I said I did not agree with that.
She's trying to promote to you to make a false statement, it sounds like. Is that accurate?
Yes, sounds like that.
I want to ask you if you posted this statement.
These are all through messengers.
I'm plugged in. Let's see. I want you to look at this statement, and I'll ask you if you typed this statement.
Yes.
Can you read that statement for the court, please, sir?
I'm going to kill this C. I just got subpoenaed. This crazy ass bitch doesn't want me to understand. How much drama can one person create? Don't pay me back the $1,000 I lent you. Just leave me the hell alone.
You had lent her actually money, correct?
That's correct.
This statement as well, sir, did you type this paragraph?
Yes.
Can you read that paragraph for the court, please, sir?
I'm over this no talent bitch starting up trouble again. I just caught a call from the Dixon County Police Department about the complaint brought up against the officers, and my name was mentioned. What you need to do is pay me back the $1,000 I have lent you and leave me alone.
You got a call from the Dixon County Police Department about a complaint brought up against the police officers, and your name was mentioned. What did the Dixon County Police Department ask you about that?
Did I recall anything inappropriate? I don't remember it was a female, I guess, sergeant and I said,
You're not.
no, I didn't recall anything that I felt
Do you have an objection?
inappropriate.
Ms. Childers?
Yes, Your Honor. This question is actually in part of a criminal investigation, which is part of what the other two attorneys spoke about. Can I have them intervene and see if the question is allowed?
Holly?
This is non-hearsay, Judge. It goes directly to Ms. Childers' credibility. She's asking Mr. Dever to get involved in filing a false police
The
report.
objection is as to the question that his conversation with the Dixon Police Department, he's reciting what he was being asked by the Dixon Police Department, which is a hearsay statement that they're asking, the question from them asking him, and his response would be hearsay. I sustain an objection. I don't think that really has a relevance anyway, but it is hearsay. Sustained.
That's all I have. Thank you, Judge.
Ms. Childers, you have the right to ask questions of this witness. It is not a point for you to argue with him or to make statements. You can ask questions in the form of a question if you wish to do so. Do you wish to ask any question?
Yes, Your Honor.
Come to the podium and you may ask your question.
Colin, how would you explain our relationship?
Well, we've been friends for 9 years. We met at a fundraiser raising money for a social service organization, and we just clicked. And, spent Christmases and Thanksgiving at your place and with your dad, and it was very good.
How would you describe my emotional state with everything going on? Is it a way that you had seen me in the past?
Judge, I would object to the relevance. First of all,
State is not relevant. Your emotional state is not relevant to the grounds for divorce or to the issues regarding property.
Yes, Your Honor. The post that Mr. Hawley showed said several times that I was crazy, and that's why I was asking the question.
All right, well, I'll overrule the objection, allow it for that limited purpose. She's trying to rebut the statements by Mr. Devers as to her mental state, so I'll allow it for that purpose.
No, and I was just so mad at you over that damn parrot of yours that I was watching that I lashed out inappropriately and used language that I should not have, and I apologize.
Thank you. Sorry, give me one moment. I just need to think how to word it. Did I ever ask you to lie to Dixon County Sheriff's Department?
See, I'm not recalling that you ever asked me to lie. I was just furious, and maybe I worded it inappropriately and wrong. I was just really mad, as you can tell by the text. So,
Without answering or providing any details of the investigation, can you state, did Dixon County Sheriff's Department indeed reach out?
Yes, they did.
Did I ever reach out to you one time asking you to say anything to Dixon County Sheriff's Department?
I'm not recalling it.
During the course of everything that has gone on, have you, I know you've had some medical issues. Were you ever under the influence of alcohol or any type of, prescribed medications when these messages were typed up?
No, I was just angry.
And I know you were a little shocked about how those messages came up. Can you tell me, did you provide those messages from your messenger to Mr. Hawley in the text messages?
Judge, I'm going to object, first of all, to the relevance of how they were there. They were there. And secondly, it goes with the discovery. I mean, I well asked to provide everything having to do with any sort of social media, anything with witnesses, all of these things that she's not answered.
Sustained. Witness will not answer the question.
Have you ever shared your social media information with anyone?
Again, Judge, same objection.
So the question is, have you ever shared it with anyone?
Yes, Your Honor, because the point I'm trying to make is Mr. Hawley, his client, has continued to stalk and harass not only me, but people in my circle, and Mr. Cullen does seem to not be aware that anyone accessed his social media account.
Sustained, because this witness has testified he's the one who posted those messages. I don't think that it's relevant whether or not there is any other issues. Any objection?
No further questions.
Mr. Hawley, you have any redirect for this witness?
I do not, Judge.
Mr. Dever, you may stand down. You are released from your subpoena. You may go about your business, or you may have a seat in the courtroom if you like. Thank you. Mr. Hawley, you may call your next witness.
I have just a quick moment, Judge.
You may.
That's our proof, Judge.
Plaintiff is rested to proof. Ms. Childress, you have the right to ask to put on proof if you wish to do so. Do you wish to call any witnesses or testify yourself?
Your Honor, I'd like to call Detective Lovell.
You'd like what?
I would like to call Detective Lovell as a witness.
Again, Judge, I would object. There was a witness list that I asked for. The court has already ruled Detective Lovell's not on here anywhere as far as a potential witness. He's a subpoenaed witness for me today, but she didn't issue a subpoena for him at all. And I object because, again, it's in discovery that I asked for this stuff.
Your Honor, I answered the discovery questions. I did. And at the time of the divorce, the people that I were going to call as witnesses are the ones to testify to the abuse, what I endured during the divorce. What Mr. Hawley has filed is a separate contempt motion against me, where at the time items were removed from the house, I was not under a motion. More or less also, the divorce had not even been filed. I'm speaking to this in regards to, these are witnesses to what Mr. Hawley is claiming, and in the spreadsheet that I did send to him, and if he can't read it, again, it's on my thumb drive. I don't mind taking a recess, but Mr. Lovell is actually listed as a witness.
And what do you intend to prove through Mr. Lovell?
With Mr. Lovell was present, so was Detective Martin in the room when I had the meeting with CID at Dixon County. It must not have been false. There's my evidence.
You talk to me, don't talk to him. Tell me what it is that you think that you are going to prove through Officer Lovell.
Because Mr. Lovell was present in many of the meetings.
Doesn't matter where he was present. What are you wanting to prove through, what are you going to ask him? What are you planning to put on in the way of proof?
I want to ask him if he was present whenever the CID team was questioning me. There was an investigation. The previous law enforcement officer that he did bring to the stand confirmed that he was reprimanded for being unethical.
Judge, I would object to this because it's a gravamen of what you've already ruled in the motion to quash, that we can't get into anything having to do with the criminal investigation.
Well,
We
Mr. Hawley,
highly contest the aspect of that domestic assault.
Something that's relevant becomes an issue before the court. It's relevant if it tends to make something more true or less true that is an issue before the court. We are trying a divorce case. We are not trying a criminal case. And as a result of that, unless it directly goes to the grounds for divorce or goes directly to the division of property, it is not relevant to the issues before the court. Whether or not this officer was present during the time that CID investigated or interviewed you is not going to prove anything that the court has to consider. It doesn't prove anything regarding the grounds. What you're attempting to do is to rebut something that you asked these officers about whether or not they were reprimanded. Well, but whether they were reprimanded or not does not go to the issue of whether their testimony was truthful or not truthful. It has to go with whether or not you feel like they acted professionally.
yes, Your Honor, my point being is because Mr. Hawley was questioning if I had Mr. Dever lie to have him contact the sheriff's department, and I did not, and I wanted to show the proof of that. But as to Mr. Hawley's point about the criminal side, Your Honor, you're correct. This is a divorce hearing. It should be in regards to a divorce. What Mr. Hawley and his client are coming after me for is theft. And my entire box, again, you can see it's been through Sheriff Eads, the DA's office, Mr. Crouch, all the law enforcement in this county. All of my evidence is based on criminal activity because Mr. Claiborne filed a false police report on me about what was removed from the house, and even went as far as reporting a gun into NCIC.
We're getting into testimony. I think the court's going to allow her to testify in a minute, but she's arguing her case.
Mr. Hawley,
We're making those statements.
I'm going to allow her to call Mr. Lovell, but I'm limiting it unless it has some direct elements. You'll need to object to anything that goes beyond the scope, but I'm going to allow him to be called as a witness since I don't think I'm going to prevent her from calling a witness, but putting on the evidence is a different matter. So Mr. Lovell will be called as a witness. I'll allow you to object and then I'll rule on it.
May I address the court briefly? You're talking about grounds for divorce, but today we're just here on a motion for contempt. This isn't the divorce trial. I'm not prepared to put on grounds for divorce today. I filed a motion for contempt because of the previous
Why
order.
are we trying? Let me say this. Does your client want to be divorced?
I would ask for default judgment for at least a divorce today at the end
You
of
want
the
to be divorced from this man?
absolutely, Your Honor.
They're granted a divorce today,
Thank you, Your Honor.
right now. Now, since we're not talking about grounds for divorce, the division of property goes without fault to, is to be equitable or fair without fault. So I'm not going to consider the fault of the parties, but it also goes to the classification of property as to whether it is separate property owned by one of the two of you before the marriage or whether it was marital property acquired during the course of the marriage. So those are the issues that are before the court. So let's limit it to that. You've now been granted a divorce. So the issues of what happened and what caused it are not relevant to this court's proceedings anymore. We're now going to go to the issues of property division, which is only about who owned what and how much it was. Now, we've also ruled that you can't put on proof about the property issues because of my ruling regarding the answers to discovery. And if those were questions that were asked during the time that these answers to discovery were requested, then I'm preventing you from, under that rule, from putting on proof about it. So what I want to know is, do you have proof regarding any issue that is still before the court?
Yes, Your Honor, I do.
What are you planning to put on?
At the time that the discovery questions were handed over to me, I had never left the marital residence. So, Mr. Hawley, there's no way that he could have asked that question. He couldn't see into the future to see what this next motion would be. The motion was filed after the fact. What I plan to present to the court, I have hundreds of documents of receipts, proof that these are my items. I have video of what.
Did you comply, did you produce all of those for Mr. Holly? All of those hundreds of receipts that you claim?
No, Your Honor, I was not asked to. I was asked specifically by the court to provide Mr. Holly the spreadsheet. And I did do that. And I have a copy of the spreadsheet on my thumb drive if anyone has a problem with how to make it out. However, based on the witnesses that are here in this courtroom, Mr. Holly was able to read that spreadsheet because Mr. Lovell is here to testify in regards to electronic devices that were handed into the city of White Bluff.
Well, if I can, Judge, interrogatory number 29
Have you filed the interrogatories in the court file?
and number 28, I have. And they're also attached to the motion that I filed for the 5th. The last time we were here, I gave them to the court as an exhibit. And then they're also attached as her answers. The questions are written out and she's got a handwritten answer. And the request for production of documents number 29, produce any and all documents and or items you intend to introduce as exhibits into the trial of this matter. And again, number 28 says basically produce anything from your spouse to others, photos, videos, any other material in any other way relating to your spouse. But I think she's stopped from putting any of that on.
Your Honor,
And again, as far as something classified as marital or separate property, I think it comes into play today from the property that maybe she took. But as far as an overall classification of everything, I mean, I'm not really prepared to get into a divorce trial today. I just filed a motion for contempt because there's some $40,000 worth of stuff that's no longer there.
I've granted you a divorce. I'm referring you to a special master regarding the identification and classification of all of your property. And we'll let someone else take the time that doesn't have all of these other folks who are needing it. So each one of you will be required to post with the clerk and master a deposit of $1,000 towards the payment of the special master's fee. And then I'll designate special master. Mr. David Brogdon will be the special master for your case. He will determine and hold an issue. I will draft an order that refers it to the special master and sets forth the issues that are to be resolved by the special master. You've been granted a divorce that terminates anything except the division of property and the motion for contempt regarding those property items. So,
Mr. Brogdon will be allowed to look at the contempt as well and determine that, or?
it will be allowed to determine the issues of property and therefore and where those properties items are located.
Yes.
Your Honor, Mr. Holly filed a motion against me in his motion saying that I'm entitled to be represented by counsel if I could not afford one. I no longer work. I do not have $1,000 to pay in this matter. Can I request that I have a public defender?
Don't get a public defender in a civil litigation. You can represent yourself. I'll reserve the issue of posting the special master's fee, but you will have to pay a special master's fee at the conclusion of the case. And this court cannot and will not devote the time that it seems to me would be required to sort through the mess that the two of you have created in your marriage of 4 or 5 months. And all of your claims in your box with evidence labels on it do not, don't particularly persuade me that these issues are relevant. But if you want to litigate them, I've granted Mr. Claiborne a divorce and you a divorce. So you are now able to go forward with division of property issues in front of someone who might have a little bit more time to devote to it. So I'm going to take a recess. I'm going to draft the order referral to the special master, and then we'll come back and I'll start the next case. So you might want to contact the next people in order.
Yes, Your Honor.
Thank you, Judge.
I'll take this from. I wanted to address an issue that I wasn't aware of at the point in time until I began to go through the file. Ms. Childress has never filed an answer to your complaint for divorce. There was no answer filed, no counter complaint. She apparently had some motions filed through her prior attorney, Mr. Baker, who filed on April the 4th a motion for an opposition to the motion for possession of marital residence. On April the 19th, filed a motion for exclusive possession of the vehicle. On April the 19th, he filed a motion for pending lighting support. And then on May the 9th, Mr. Baker filed a motion to withdraw, and that was heard and granted. No answer has been filed to the complaint for divorce. No answer has been filed to your motion for contempt. A party appears from the record according to the documents. So therefore, this court is revising the judgment that I previously entered. Your motion for default is granted based upon the fact that Ms. Childress has not filed an answer to contest the issues that are before the court. And a default judgment means that you, as though you never appeared in this court. And as a result of that, Mr. Claiborne is granted the motion for default judgment as to all the issues that are raised in the complaint. And therefore, the court, having heard proof on those issues, grants your finding of civil contempt in the amount of damages that you have set forth at the prior hearing. You'll draft an order and submit that to Mrs. Childress. Ms.
Your Honor,
Childress.
I was never given the opportunity to prove that I submitted those responses.
But I want you to understand this has nothing to do with the issue that you are talking about. This has to do with the fact that a review of the court's file, and the court speaks from its minutes, demonstrates that you have never filed an answer to the complaint as required by the rules. As many of the other shortcomings of the handling of your side of this case, the complaint alleges various items that you are guilty of all of these different things, and including inappropriate marital conduct, cruel and inhuman treatment. And it shows that you don't own any real property and that you are various property subject to a equitable division. A default judgment means that you not having answered the complaint and raised those as issues, that there's nothing, and that there was no answer filed by you or Mr. Baker as to the motion for contempt. So therefore, you have not technically appeared in this court as a party, even though there were some motions that were filed on your behalf that were never completely litigated.
Your Honor, the divorce and the contempt are two separate issues. I answered the interrogatories like I was asked by the court. I provided those responses. I don't know how to do this, but I can't represent myself or hire an attorney when there's over 50 motions being filed on me in this courtroom. I provided my responses. I just wanted somebody to look at the thumb drive to see I'm telling you the truth. Mr. Hawley, it was pointed out numerous times in the last two court appearances that he did have my answers. He quoted them on your stand. I watched the YouTube video back. I did provide the answers, Your Honor. The divorce should be two separate matters. There was nothing removed out of that home while I was under any type of restraining order. When the devices and the information that I provided to law enforcement at the request of them was handed to them before the divorce was even finalized. I have my evidence to prove all of this, but I've never been given the opportunity to present it to the court.
As I explained to you earlier, it's not a question of whether you delivered or did not deliver something. You did not comply with the order of the court regarding the rules of civil procedure, which apply to you as they do to every other person. And I have, in this court's opinion, bent over backwards trying to assist you and trying to give you an opportunity to do these things that are required by the rules. Because of the fact that primarily, I just learned from my review of the file that no answer had been filed to the divorce complaint. I was in error in not granting a motion for default to Mr. Hawley. A motion for default means he wins because you actually didn't show up in the sense of a legal proceeding. And for that reason, it seems to me that there's really nothing more that I can do for you because as a part of the divorce action, The motion for contempt was a violation of the statutory injunction. That should have required an answer to be filed by you, and although we had an extensive hearing, you have never technically appeared on that issue. You have not filed a response to it. You have not you have not filed an answer to the complaint for divorce. So I understand you may not agree with my ruling, but my ruling is based on simply on the law and the rules of civil procedure that apply to every person who appears in this court. You can consult an attorney. There are procedures that you can follow to try to address this issue in some sort of a motion that you might want to file if that's what you decide to do. But you may want to consult with an attorney about that first.
Your Honor, I don't have the money. Do I have the option to appeal, to have it heard in another courtroom?
You have every option available to you under the rules of civil procedure.
Your Honor, in the motion that Mr. Hawley filed on me in that contempt, it said that I have the right to legal counsel. It was signed off on.
It's because he filed it and gave you a notice of rights, but he's filed it as a civil contempt rather than a criminal contempt, which means you do not have the right to an attorney. Civil contempt means I'm not going to incarcerate you in jail, and for that reason, you do not have the right to have an attorney appointed for you.
But Your Honor, it was listed as criminal contempt. That's why I didn't understand why it was in your courtroom.
I'll draft the order, Judge. For the court, I'll draft the order.
That is judgment of the court. She's not found in criminal contempt anyway. It was civil contempt on the issue of these items being removed. Even if it was just as a hearing on the division of property, she didn't appear in the divorce itself, so therefore this court is of the opinion that the plaintiff's proof should prevail. You can consult an attorney, you can consult the rules, you have every option available to you for someone who is disgruntled with an order that the court puts down. That is the conclusion of everything I'm hearing in this case.
Yes, sir. Thank you, Judge.
Your Honor, am I divorced? Am I
You are
divorced?
divorced.
Thank you, Your Honor. Take your contact with your.
Ma'am, you can leave.
He keeps
You can
harassing
leave.
me. That's his attorney.
You can leave.
Sorry, Judge.
Brian Grammon versus Tony Marie Grammon.